Sí,
Okay.
Miss,
He needs an interpreter.
he does?
Yes.
All right. Ma'am, do you need an interpreter too?
Y,
Señora, ¿necesita usted un intérprete también?
sí,
Yes.
He will, Mr. Guerrero will be your interpreter for this hearing. I have both the plaintiff and the defendant present on
No en
Zoom.
presencia física.
sí.
This is
Yes.
on case 2455. This is the plaintiff mother's motion to enforce basically an order of the court. The court issued an order on July 26th that says during the pendency of this divorce that the parties will do what's called a nesting agreement, and that they will each live in the house for a week, and then, you know, one of them will move in, one of them will move out, and keep doing that. Plaintiff mother says that the defendant father has his mother move in when she gets the house. Is that correct, ma'am?
Sí, señor juez, pero el señor Jiménez no obedeció esas órdenes del juez.
Yes, Your Honor. But Mr. Jimenez did not obey the orders from the judge.
Well, why do you allow the mother in there, ma'am?
She has to be alone with her kids in the house. But Jose Jimenez didn't say anything to the mother.
I don't understand. Why do you allow the mother there?
Por eso le
Just to help her because before we were living together with an uncle. Yes.
So you have the right to have anybody there during that 1 week that you have it if you want. Mr. Jimenez isn't moving in the house during that week. He's not violating the order. He doesn't live there during that week. If you don't want his mother to live there, don't let her live there. She has no rights to be there.
Ok, señor juez. Cuando
Okay, Your Honor.
ingresé la primera semana, yo hablé con la señora, hablé con el padrastro del señor Jiménez que buscaran dónde ir.
I talked to them. I talked to his mother, Jimenez's mother, and he and the lady's husband, stepfather to Señor Jimenez, to go and look for a place to live.
Y
And
yo,
the lady, I'm not leaving the house. I'm not getting out of this house, and you're not going to kick me out.
Repeat that, please.
The lady told her, I'm not leaving the house. I'm not getting out of here, and you're not going to kick me out.
Does she live there? Has she been living there for years or what? What, sir?
¿puedo hablar?
Can I talk? Mr. Jimenez want to talk.
Yeah, what do you want to say
No
briefly?
es fácil echar a una persona. No
Okay,
es fácil echar a una persona de la noche a la mañana.
Patty.
Mr. Guerrero.
The mother has been living there with them. She lived with them for the past 10 years, and she also let them have the money to buy the house. So, but now the mother knows that she has to move out of the house.
Y en estos pocos,
Hold
en
on.
estos
Yeah,
casos,
Patty. He also had two little brothers that live with her, and they don't have a place to go, and so he don't want them to get out of the house, I guess. They're looking for a place to go, and in 2 or 3 weeks they will be moving out.
Ma'am, you're gonna either have to evict them if it's your house.
Sí,
because they've apparently lived there for 10 years and you
No,
can file to evict them.
Y usted puede agarrar una orden de la corte para echarlos para afuera.
The order says that Mr. Jimenez will not be there for that week and he will not.
el juez me dijo así.
Yeah, I guess that she has been trying to do that, but Mr. Jimenez has kind of opposed that.
It's kind of what?
Opposed.
Oppose it? Doesn't matter.
Opposed. No importa quién se oponga, usted tiene la autoridad.
Mr. Jimenez just said here that they'll be out in a couple weeks anyhow.
sí, a pocos días les quedan, ya se van a ir de la casa. Ahorita no tienen dónde ir. Con los niños, ¿dónde se van a poner? No sé si pueden esperar el juez.
I don't know if the judge can wait 2 or 3 weeks before they can get out of the house because they don't have no place to go.
I'm going to deny this motion because you get exclusive use of the house as with Mr. Jimenez, week on, week off. Court didn't order anything with other people that live in that house. You'll have to take appropriate steps to get them out of the house, but it's not through this divorce proceedings necessarily.
I want just this to clarify to Mr. Jimenez so he can talk to his family to get him out of there.
That's fine.
Ya está muy bien.
Mr. Jimenez, get your family out of there.
Señor Jiménez, le dice el juez que saque su familia de ahí.
But I'm denying because Mr. Jimenez has not violated the order himself. And good luck. Thank you. We're
Buenas
adjourned.
noches. Gracias.
Gracias.
Branham versus Bussing. Both parties are present, as well as Attorney Victoria Lynn on behalf of the defendant mother. There's a 1-year-old child here. This is mother's motion to consolidate cases and for child support and whatnot. My understanding is that there was a DS case filed by the prosecutor's office some time ago, but was dismissed. In dealing with your first issue of consolidating, I can't consolidate with a case that's dismissed. End of story. I mean, there's nothing to consolidate. The case was dismissed August 8th, I believe, through an order of the court. It's dismissed, so there's nothing to consolidate.
Your Honor, if I may, the reasoning behind that motion to consolidate is that Ms. Bussing was relying on the prosecutor's
I
office.
understand that. You can make that argument if you want, but bottom line is I can't consolidate with a case that's dismissed.
Okay, as to, it is a retroactivity issue though, in that she's looking for child support retroactive to the date that Kent County Prosecutor Office filed that action. So could we, I guess, ask for child support to be retroactive to that date?
I don't believe that I can go back, or do I intend to go back? She filed a case and asked for child support. When did you ask for child support starting? Well, you asked for it when? Must have been last month. No, yeah, it started last month. You know, I'm also, I will send it to the friend of the court for a child support recommendation on this. We can deal with the retroactive nature of it. It certainly would not go back very far. It certainly will probably go till when you filed the motion, which was August 20. The best it'll do is probably go back to August 1st, but that's something you can argue when we get the child support recommendation from the friend of the court, because I don't have any idea. How are you proposing that your client makes nothing? How does she live on nothing? She doesn't get child support. She doesn't get anything. You're claiming that she has zero income.
Right, and that's something, if we refer to friend of the court, she can provide some more information to friend of the court at that point.
Well, I'm asking you because you're asking for attorney's fees based on her making nothing. That means she has a child at home that she has no income for, and I can't imagine that that's true because she's living in a house.
Right,
Who's
yeah.
Who's providing that house?
Right. I believe there is some public assistance in this case, as well as help of her parents.
So, yeah, so there is, and believe me, she's going to be imputed. She can't just sit at home and make nothing. So, as far as the motion to consolidate the cases, obviously I'm denying that because there's nothing to consolidate it with. You can make your argument as to why it should go back for a while, but we'll see when the friend of the court recommendation, both parties need to cooperate with friend of the court recommendation. I can reserve attorney's fees. I'm not going to give you any right now because I don't know how much he makes. And literally, you're putting in here that she makes absolutely nothing, and I know she's not living on nothing. And whether it's a free house and that kind of stuff, that can be considered as income. If she's getting a rent paid for her and whatever is going on. So, I'll reserve attorney's fees. I'll make the referral to the friend of the court. If you wish to file an order saying that, I reserve attorney's fees, that's fine. Mr. Branham, anything you wish to add to this or subtract or whatever?
Not at this time.
I mean, you're going to end up having to pay child support, and it's probably going to be like either, it certainly will be starting at the latest will be August 20. So you're going to be behind in child support. I suggest you start paying some sort of child support, or you're going to be in arrears as soon as we enter this order. But if you do, you should make sure that you pay it in a manner through Miss Lynn, maybe that says, I'm paying $100 now. I want credit for child support, so that you get credit. If you just give her cash or something, you're not necessarily going to get credit for child support.
So on that note, I would like to state that with the paperwork we've submitted to the court, there's listed nearly $2,000 between the end of March and when the paperwork was filed in the middle of April that I have sent in support of my child.
You're gonna have to work that out. I don't know what, I'm not making a ruling on that right now, but you understand, you need to make sure that you're giving credit for it, all right? And any other money that's sent, I'm telling you, you need to make sure that maybe you need to send it to Miss Lynn and say this is child support. All right. Do you understand
Yeah,
what I'm saying?
Yes.
Miss Lynn, anything you want to add?
Yes, we'd be happy to take care of that if he wants to provide child support to our office. Thank you for reserving attorney fees, and then Your Honor, you stated you'll prepare the referral to a friend of the court
That is
order.
correct. That's correct.
Okay, thank
Right.
you.
You're gonna get stuff from the friend of the court. You guys got to abide by it, or else they're gonna make decisions without your input. All right?
Yep.
Thank you very much. We're adjourned.
Thank you, Your Honor.
8-4, both parties are present with their respective attorneys. That is, Miss Bills is represented by Mr. Murphy. Mr. Bills is represented by Miss Bueno. This was the plaintiff father's request for parenting time, child support, and extracurricular support. Let's start out and do the easy one. It's clear that we're gonna have to modify parenting time somehow because Mr. Murphy, your client moved to New York, and we're obviously not gonna do every other weekend or something like that.
That is correct, Your Honor. We'd like to modify, and I think both sides want to modify, yes.
All right, and I don't know that you guys have reached an agreement on modifying, although I would ask that the two attorneys discuss the matter so that they can try and reach an agreement. I think the best thing to do is either to send it to mediation, or quite frankly, if the two of you want to set up a settlement conference with me, I'll give you a half hour or something in the real near future to try and work something out. I mean, there's only X number of days that she can get. It's summers and breaks and stuff like that.
Agreed, Your Honor. We're happy to talk to the opposing counsel on that. I think we can work something out.
All right, Ms. Bueno, it's your motion, but I mean, I'm not going to find anything here today. If we have to, I'll have an evidentiary hearing, which would be god awful for just for parenting time when we know
Right.
certain things about it.
I would just add that I did have a chance to speak with opposing counsel yesterday. We're close, but not close enough, just based on the lack of parenting time that the defendant has chosen to have up to this point. So, I mean, I think having a settlement conference with you to get your feedback on what we should do going forward is probably the best solution.
Well, I'll ask the two of you. That's fine. We'll try and get you in here in the next week or two or whatever for a quick settlement conference. What it would be then is I would ask the two attorneys to come into my office, and I'll give you my thoughts on it, and we'll see if we can't figure something out. All right.
That'd be fine, and I'll provide a updated proposal to Ms. Bueno also.
And that would be great. I want the two of you to provide proposals to each other before you get in here, so I know where we're at least if I have to work on some of that. My clerk will get in touch with both of your offices and try and set something up. Yeah, it's either got to be later next week or like 3 weeks down the road, because I'll be gone for a week. So we'll get you in as quick as we can. Although there isn't any real, quite frankly, real rush on it, because there isn't going to be parenting time in September and probably nothing really in October. We got to get something on the books before we get to Thanksgiving and that kind of stuff.
Right.
Very good.
We'll work with both of you and see if we can get you in here, okay?
All right.
All right. Child support. I'm going to hold off a little bit on child support because basically that's going to depend, some of it depends on number of overnights, and we're going to figure that out at the settlement conference is what the number of overnights are going to be. They're not going to be a huge amount, I'm sure, but there was a UCSO of 52124 that listed 52 overnights. Ms. Bueno, anything you want to say?
I would just ask that if the defendant has actually started her job in New York, that we be provided pay stubs for that.
Yes, I am employed.
She's employed at Target, as I understand, the same as she was employed at Target here.
Well, I mean, my client hasn't received any child support since the beginning of August. So that's why we're a little confused on why there's a big gap.
The whole reason for that was I took a leave of absence to make the move. So he will get that money on retro. They garnish my wages. It's taken out every paycheck.
Target takes it out.
Yes, sir. Yes.
You get it. You'll get what they take out and stuff like that, and any other enforcement you can do through the friend of the court. But basically, it looks like there was brief time period of, they were not taking it, but she's telling you that they are taking it out of her check, and you know as well as I do that there's a delay between taking it out and getting it.
Right, I would just ask for some pay stubs, so we have accurate information.
And vice versa, please, regarding your client.
Yes,
Okay, you guys can exchange pay information and do it within a couple weeks, 2 weeks.
Yes.
All right. Final deal here is regarding extracurriculars and or this payment to Sylvan Learning Center is the big one. Is that correct?
yes. The Sylvan, we're asking for 2,700 reimbursement. And then,
Was there an agreement for this beforehand?
Absolutely not.
well, Your Honor, my client reached out to the defendant a couple
Ms.
times.
Bills, I want to tell you, you don't talk unless I ask you to. Go ahead.
Okay, I was just gonna say, regarding the tutoring, my client did reach out to the defendant several times and didn't receive a response. He chose Sylvan because that's what the primary care physician suggested, so he went according to the doctor's orders and proceeded that way with it. And you know, the exhibits show that it worked tremendously and the child is doing great in school because
I
of that.
understand, but you know, he's asking also for extracurriculars and stuff like that. He complains about stuff like she hasn't paid for senior pictures and there's nothing in the judgment about payment for extracurriculars, okay? And I can't just add it to a judgment years after the judgment was in there. If the parties had put it in the judgment, then that's fine. But you're asking for something that is not in the judgment of divorce.
That's correct, Your Honor.
And I mean, if you can point it out to me in the judgment, that's fine. But other than that, these are extracurricular activities she's not required to.
And
No,
frankly, Your Honor, we believe that he's, you know, that's an exorbitant cost. That's a big one. He needs to get pre-approval, and he's trying to nickel and dime her on this entire matter for whatever reason.
Your Honor, he's not trying to nickel and dime her. He's trying to get the kids whatever they need. And I understand that it's not in the judgment of divorce. But I mean, that's part of the reason, part of our motion now is because he's had such a hard time trying to get any kind of assistance. And so he's asking, you know, at least from this point forward to get assistance.
Well,
You know,
Mr.
Hold on, Mr. Murphy. You're asking to modify a judgment of divorce from 2016 or 2017 or something like that, and on a property type matter, and it's not modifiable for that. It's just not.
I'm not asking to modify it. I'm asking from this point forward.
That would be a modification because you're asking from this point forward. Okay?
That makes it a post-judgment matter, not a modification of judgment matter.
Okay, then what you can call it anything you want. I don't find that I'm in a position to modify that judgment to going forward, that it would be a part of a judgment that they're extracurriculars. I'm sorry, it's a bad deal for your client, and I'll tell you he's doing a great job and she's not helping out very much, but it's not in there. And I'm not going to modify and now add something, because that's what you're asking for, is to add something basically to the judgment of divorce to have her responsible for extracurriculars in some percentage, and it just isn't there. If he had gotten some kind of an agreement from mom to say, okay, yeah, we need to get her to go to Sylvan and that kind of stuff, and it had come up, that'd be some kind of an agreement that I'd enforce. But by saying she didn't respond at all, now you want that to act as kind of an agreement, and it just is. It's harsh, but it's there is nothing in there that requires her to pay extracurricular type of activities or events.
Okay, I understand.
Thank you, Your Honor.
I'm sorry. Anything else, Ms. Bueno, you want to put on the record?
No, I don't have anything else.
All right, then who's going to draft the judgment there, the order that says that is denied? I will set a settlement conference as promptly as possible regarding parenting time. Parties shall exchange in 14 days financial information and pay stubs, basically, and that will reserve child support pending the parenting time order.
I'll draft this motion.
All right. Thank you.
Thank you, counsel. Thank you, Referee Frederick.
All right. Thank you all. Have a good day.
Thank you. Have a good day.
Are you handling all the prosecutor's motions?
I'm handling them all. I'm the last man standing.
All right. All right. Well, why don't you come here and you handle this too? Okay. And I'll go home. Everybody.
I don't think I'm capable.
Yes, I know you're capable. Ms. Treestrom, you can hear me all right?
Yep.
Mr. Felix, are you there? you're muted. Unmute so that I know whether or not you're there or not.
Yes, sir, I'm here.
All right, this matter of Treestrom versus Felix. We have both parties present via Zoom. We also have Ms. Michelle Smith-Lowe from the prosecutor's office. Prosecutor's office has sent forward a judgment of support regarding this matter. There's clear, I believe the only state assistance apparently is Medicaid, if I'm not mistaken. Ms. Smith-Lowe, you've sent through a order just asking for that, even though it appears that child support would be about $500 a month if Mr. Felix was ordered to pay it. You're comfortable with a deviation like that, Ms. Smith-Lowe?
Thank you, Your Honor. I'm actually handling this for Ms. Rummelt, and she met with the parties on July 1st of this year. Calculated, deviated to reserving support at this time because Medicaid is the only public assistance at this time.
Ms. Treestrom, what are your thoughts?
That's fine.
You don't want child support, you just want the medical portion?
That's okay.
Well, I mean, this is actually for your child, it's not for you, it's child support, but you want to deviate to there because what, does he help out?
Yeah.
You guys basically get along and share the child and help out and with each
Yeah.
other?
Yep.
All right, Mr. Felix, I can't imagine that you are going to object to this because otherwise you'd be paying $500 a month. You are going to continue to work with Ms. Treestrom for your child. I believe your child's Oliver.
Yes, Your Honor.
You guys are going to cooperate the best you can. If either party at any time decides that this isn't working out anymore, you can file something with a friend of the court asking them to look at child support. But with your agreement on everything, I'll sign the order that calls for only, I think it's like $29 a month or something, $23 a month for the ordinary medical, so that can be paid to the state to reimburse them for the Medicaid. All right. Good luck, everybody. I hope it continues to work.
Thank you very much.
That'd
Thank
be
you.
really nice. Thank you. Take care. We're adjourned. 06DS. Both parties are present via Zoom. Do either of you have video? You're supposed to be present so that I can also see you. We have Ms. Smith-Lowe also present. I see Mr. Walker. Ms. Williams, turn on your video, please. We also have Ms. Smith-Lowe from the prosecutor's office. She has sent through a request for a judgment of support in this matter. Based on the parties' earnings. They also, she finds that apparently they come close to sharing. Mr. Walker gets 156 overnights. There's actual income from both parties. Ms. Smith-Lowe, is there anything you'd like to say? Perhaps can't hear you. You're talking.
I am talking, but.
All right, I can hear you now. Maybe lean in a little bit.
Okay, I
right.
will. I just wanted to place on the record that I met with the parties at a pre-hearing conference together on July 17, 2024. The parties agreed, and the documents were sent to them via DocuSign, but they weren't returned to me. So this was scheduled, but I do want to place on the record that the parties were clear on wanting joint legal and physical custody, and they did not want to work with FOC. And so those terms are included in the judgment. In the judgment, that these are terms that are typically not included, but they do include that neither party, that the 100-mile rule, and that neither party can take the child outside of that area. No change in domicile without the court's permission.
And $83 is the child support amount?
$83 is what they agreed to during the pre-hearing conference, Your Honor.
I don't know where it's in here.
Paragraph 8 and 9. And then there's also an attached, parenting schedule. There should be there will be an attached schedule in the event that they cannot agree with regard to holiday parenting.
Parties agree to joint legal and physical custody. Neither shall remove the child domicile without first obtaining written approval. The 100-mile rule, parenting time shall be as agreed. It's as agreed, or is there going to be an addendum that?
There will be an addendum for holidays, Your Honor.
All right.
The typical alternating holidays.
All right. And if they do not want the friend of the court, they'll have to do appropriate steps to opt out of the friend of the court, quite frankly. They'll have to sign the appropriate things through the friend of the court to opt out.
Okay.
Other than that, Mr. Walker, is that your understanding of what the agreement is, joint legal and physical? You guys are going to agree on parenting time. Your child support is basically $80 a month, I think, about $20 a week. Is that your understanding?
Yes, it is.
Ms. Williams, same to you. Is that your understanding of what we've got here?
Yes, it is.
All right, then, with the understanding that I'm also gonna get a, parenting time schedule with this, I will sign it, when it's presented, if no objection from either of the parents. Thank you both very much. I hope you continue to get along. If you don't want the friend of the court involved, contact the friend of the court and ask. I'm not positive. In fact, I think the friend of the court has to be involved as long as they are collecting. There's Medicaid apparently involved with this, and they would have to collect for the state of Michigan. So I don't think you can opt out of the friend of the court at this point. Once that is done, if there's no more Medicaid, you can opt out. But as long as they're collecting for the state, you'll have to pay it through the friend of the court because they'll take the part out for the state. Okay?
Yeah.
Turner, I believe they didn't want to deal with friend of the court regarding parenting time and custody.
Okay, well,
They understand that enforcement will be through
I just
FOC.
assume that they probably don't want anything to do with the friend of the court, but I'm just telling them they've got to have a little bit to do with them
Right.
at this point. Good luck, everybody. I hope you get along for your child's sake. Amari, isn't it?
Amari, yep.
Yeah,
Yeah.
good luck. Thank
Thank
you. Take care.
Thank
We're
you.
adjourned.
Thank you, Your Honor.
Right.
It's the matter of Rodriguez versus Carrillo. We're going to Mr. Rodriguez, or Mr. Romero is the interpreter. Mr. Romero, please raise your right hand. Do you solemnly swear to interpret to the best of your ability and not divulge confidential communications?
Yes, I do, Your Honor.
Thank you. Good seeing you. Do you want
Good to see you, Eduardo.
Mi nombre es José Armando.
No, mi nombre es Eduardo. My name is Eduardo.
Okay.
Okay. I'm just introducing myself. Me estoy presentando.
Okay.
All right. We're here for a judgment of paternity that's been requested by the Kent County Prosecutor's Office and entry of a uniform child support order. Both parties are present with interpreter Mr. Romero and Miss Michelle Smith Lowe from the Prosecutor's Office. I have reviewed the file and clearly father has been tested and is 99.9% the father of the children. So I assume, sir, you have no problem in entering a judgment of paternity, making you the legal father.
Por supuesto que no.
Of course not.
All right. Then we also have a uniform child support order that says that you have basically every other weekend, 52 overnights a year. I have been told that mother is self-employed and father is employed. And as a result, we've calculated according to the child support guidelines. And Mr. Carrillo, for 2 children, it's $920 a month. For 1 child, it's $601. Ms. Smith Lowe, is there anything you would like to state?
Yo,
This case, I'm covering this case for APA Brower, and she met with the parties on August 20th of 2024. She used actual income. Obviously, as the court has stated, she did not use Mr. Perez Carrillo's overtime. She did give him an adjustment for having 1 other child.
Hold on a minute.
Es
I'm
una de las
sorry.
cosas.
yo
Here
se lo
is-
mandé por. Disculpe, yo se lo mandé en el mismo sobre donde usted recibió toda mi información.
I did send it to you in the envelope. Could you send me all that information?
I don't understand what you're.
No, no entiendo qué información mando.
Los pay stop,
No,
The
she had
pay
that.
stub.
Yeah, she had the information and she used actual income. She did not use any overtime.
pero tengo una duda.
But I do have a question.
O sea, me están tomando en cuenta, o sea, mira, cuando yo salí de la casa, yo no peleé nada, yo no, con mis hijos, por la madre de mis hijos.
When I left the house, I didn't ask for anything. I mean, I'm 100%. I agree with taking care of my children. I do want you to take in consideration that the money that they're asking, it's unreal. One of the things that they're taking in consideration, it's like they're taking the double of what I make at work. I can't really go to Walmart and pay with money that doesn't exist or pay my bills with money that doesn't exist. I'm 100% on board that my children need that support, and I wish I could give more. In fact, I would like to give more. And in
Really?
fact, I'm not a millionaire. I don't have $4,000.
Dollars. Listen, I'm going to tell you this. All right. Your income was verified and was sent in to the prosecutor's office. Your gross income of approximately $4,000 a month. All right. Also, you're given credit for having an additional child to support. Mother's income was verified through her self-employment. Your overnights are determined that I think you get about every other weekend, it looks like. So the calculation is 52 overnights a year. That's put into the computer from the state of Michigan, and it tells us what the appropriate amount is. And that's what came out, regardless. I understand you say I can't afford it, but that's the amount unless you can give me a deviation factor which doesn't exist in anything you've told me so far.
Como el juez dice, sí, es verdad, pero eso no es lo que yo recibo.
Hold on.
In the pay stub, it does show the gross income of what I make, but that's not what I receive. But I can send you my statements.
It is figured out with your gross income prior to taxes and everything. That's what we put into the computer.
Correct.
The computer figures out the taxes. The computer figures out what the appropriate taxes are. That's what the amount is based on. There is nothing that you have given me that I can deviate from that amount.
Well, I don't know exactly what are the papers that I need to send you so I can prove my point.
There aren't other papers to send me. We take the income from the parties, the overnights, you're given an additional child. That's what is based on. They say you pay child support first and any money you have left, you live on. Ms. Smith-Lowe, is there anything you wish to add?
Señora.
Oops. Lean in. I can't hear you. Still can't hear you.
No lo puedo.
Also asking for genetic test costs of $88.
That's fine. $88 for the 2 genetic tests seems reasonable. Anything else, Ms. Smith-Lowe?
Nothing, Your Honor.
Didn't you indicate that they haven't even taken into account his overtime?
Correct.
Or if we take into effect overtime, your child support will just go up.
Pero si llegáramos a calcular su sobretiempo en el trabajo,
haven't done that as of this time.
subiría, pero no lo hemos hecho hasta ahorita.
Ms. Rodriguez, you have sat there quietly through this whole hearing. Is there anything you wish to say?
Y con el arreglo de que él tenga los niños cada weekend atendados.
The only thing that I would like to just keep the full custody of my children and just continue on with every other weekend for the overnights.
At this point, the prosecutor's judgment says that you have custody and that we don't get into making rulings on what the parenting time is, but the parenting time has been every other week. I've received nothing through Mr. Carrillo's statements that enable me to modify the order that has been presented. I will sign recommending the entry of both the judgment of paternity and the UCSO when I'm presented, probably through DocuSign later today.
Okay, yo quisiera que custodia compartida.
I would like to have shared custody.
File your motion.
Entable su moción.
Muchas gracias.
But I don't know that, I mean, you're gonna have to try and meet the legal standard. Good luck.
Thank you very much.
Good luck, everyone. Thank you. We're adjourned. Thank you, Mr. Romero. Thank you very much.
Thank you. It was nice to see you.
Ms. Smith-Lowe, is that the last one you have, or do you still have one more?
Actually have.
Oh, number 9. Number 9.
And nobody's here on it.
Number 9. Do you know the Beatles' White Album?
I don't know the title of it, but I'm familiar with it.
It's called the White Album.
Oh, okay. Oh, the White Album. No. Yeah, I'm familiar with the music of it. Yes.
Yeah. Well, there's a song in there called Number 9.
Oh, number 9. Yeah, number 9.
Yeah.
My father took me to see the Beatles at Kaminsky Park. I was 6 years old. That was their first time in the country in Chicago, and there was so much screaming and fainting and ambulances on the ball field that you couldn't hear the music.
Yeah, but you actually saw
Yep.
the Beatles.
Yep.
I never did.
That dates me.
Yeah, but you were really young. I was older than that because it was, what was it, 64?
Yeah, I was sick. Yep, it was 64. I was 6 years old. Mm-hmm.
No, I wish I was that young.
I was a big fan at 6 years old.
I wish I was that young again.
Me too.
Whew, so
think of all the things I would do over.
Yeah. Yes, if we could only live our lives backwards. We know some of the stuff to avoid when we were younger now.
Yes, with the wisdom we have now.
Yeah. Oh well. All right. Well, we're here in versus Webb. We have neither party present. They were scheduled to be here at 8:30. Nobody's showing up. Ms. Smith-Lowe from the prosecutor's office. has shown up. This is a request for a judgment of paternity. I note that the father did not want a DNA test, so I assume he has no objection to being entered as the legal father. You have gone through calculations with father making $16.50 times 35 hours. Mother makes $18 times 35 hours, or at least was imputed at that because she was a tech at advanced autism for a while. I don't know if she's still there, but is there anything you wish to? I have gone through like the mother's imputed income checklist here, find that she was a behavior tech at advanced autism. She's 23 years old, high school degree, doesn't have any apparent disabilities. I mean, unemployment's still really low. State of Michigan is 10.33 an hour, but she clearly is capable of earning more than that. No other information was gleaned. Anything you wish to say, Ms. Smith-Lowe?
With the exception that I did hold a pre-hearing conference with Ms. Charleston on August 20th, 2024. I was unable to reach Mr. Webb, and she knew of no other number that I could reach him. So we're asking for entry of the judgment of paternity and UCSO as proposed.
It appears appropriate, as I say, in looking through the file, and I'm remembering, I hope I'm remembering right, but he did not even want, he says, I've had Nyla from November to April, haven't asked Kiana for anything. In his answer, he says he does not, he is not requesting a DNA test. So
correct, Your Honor. He was served in our office and did not request a DNA in his answer.
Right. Then I believe the orders are appropriate at this time, and we'll enter them at the time that I'm presented them.
Thank you, Your Honor.
All right. I think that's all you have today with me.
Well, I actually was prepared to, were you handling Mr. Douglas Bacot's motion for, what did he motion?
I do have one in here that I didn't even know if you were actually, if the prosecutor's office was notified, and it's like a DP case or something. Yeah.
Motion regarding custody.
Mr. Bacot and Miss Bulks. Are you here on that one then?
I am.
Okay, because are they here? We're just checking.
Okay.
Because my question was, had they even served you? Did they serve you with this?
I believe I'm actually appearing for Ms. DeHaan, and I believe she did have notice of it.
All right. Phone number 5192. What's your name?
Kaviano.
You're gonna have to say that again louder.
Kaviano.
KDM. How do you spell your last name?
Buck. B-U-C-K.
Oh. Buck?
Buck?
All right, we're just finding
Yeah.
the answer list.
Okay, just defendant has been logged in on this one.
All right, just the defendant. We'll call him in, Mr. Bacot.
Hey, Tracy, can you give me the case number for Miss Buck? Because her name sounds familiar, but I wasn't prepared for it today, but that sounds familiar.
Well, I don't know that she's here. What is the number on that?
It is 19-08640.
But that's not a prosecutor's one. What number is in the motion is that?
Number 8.
2019-008640.
Yes, yep,
Barnes v. Buck.
correct.
This is a motion, that was a motion. Looks like for custody.
Okay, we didn't receive any notice of that.
All right. All right.
Our case is complete.
Yep. All right, we're here in the case of Bulks v. Bacot. The defendant is present. Did you notify, I mean, we've got the prosecutor's office because this is a current pending paternity case. Sir, did you send a notice of this to Miss Bulks?
Yes, sir, I did.
Did you mail it to her or what?
Yes, sir, I mailed it to the last address I had. It was Arda, Michigan.
Wait, and you mailed it a couple weeks ago or something?
Yes, sir.
All right. She has not appeared. This was a date and time set for the motion set at 8:30.
Your Honor, I'm sorry to interrupt the court. Can Mr. Bacot repeat the address that he used?
We're on YouTube, so I'm not gonna have him.
Okay.
All right, I'll get it to you. My clerk will email it to you because that's what's on the on the, this 110 is the numbers. I don't know. Do you have something different?
I do have something different.
And you've been in contact with her?
We sent a pre-hearing conference notice to her, and because her address is suppressed because of confidentiality for some reason, possibly family violence. I can't. Her address is suppressed, but that is not the address that we have.
All right. Well, so it's very possible she doesn't even have notice of this. However, this is Dad's motion for custody. And as of right now, sir, I understand there's a paternity test that shows you're the father, but there is no order as of now that makes you the legal father. We have to get that order entered before you can even be considered for any type of custody. And that's just a procedural thing, but it has to be entered. Nobody's entered an order at this time. So your request for custody, I can't even deal with it because you are not legally the father yet. We've got something that says a DNA test, but that isn't enough. There has to be a court order. And I don't know where you're at with that, Ms. Smith-Lowe. I can't hear you.
I've been handling this case for Mr. Hahn again, and this case was scheduled for a pre-hearing conference on, the complaint obviously was filed, served, answered, genetic testing was done. Pre-hearing conference was scheduled on September 3rd, but because Mr. Hahn was out of the office, that pre-hearing conference was rescheduled, and so the case needs to go that route and be continued in order to get the judgment of paternity entered.
Right. So what she's saying is there's a pre-hearing conference going to be coming up at some point, whatever it is. I can't enter any custody order for you until I have an order that makes you the legal father. And that's not done at this time. You can renotice this somewhere down the road if you want, once an order is entered, but I can't do it until you are legally the father.
Okay, so how do I go about doing that? Because the last thing, because I've been in contact with Kayla, she's contacted me like 3 times and told me that she was trying to take the child to Texas, right? And I'm trying to stop that, and I'm trying to establish paternity because I thought that the paternity test would do that, but I just need to know
why that order has to do that. I mean, there are technically ways that somebody could object to it and things like that. I know you're not objecting to it. Best thing you can do is contact Mr. Hahn at the prosecutor's office to see if we can streamline you even being considered the legal father. I just can't do anything until you're the legal father, and there is no order making you the legal father. So, and I can't really give you legal advice. Try and contact the prosecutor that's involved with this case. Okay, you have it on some of your papers.
Right. The order, the previous court date was for child support and things like that. So, and that was supposed to establish my parental rights. Is that what that was for?
It probably was going to enter up order, but I don't know. It's not done at this point, so I just simply can't do anything. You're not considered the legal father until then, so you'll need to take whatever steps are necessary to establish that. Maybe you need to hire an attorney or at least get in touch with the prosecutor's office and talk to them about how this is proceeding.
Your Honor, the pre-hearing conference has been rescheduled. If Mr. Bacot could, follow the process, then the judgment of paternity would be entered.
I was trying to do this ex parte. That's what I was trying to do because she was trying to take the child out of the state of Michigan. That was the last message I received from her when she was moving to Texas.
We'll see what happens. I can't do something until you're the legal father. So as Ms. Smith-Lowe is saying, maybe you want to follow the process. Do you know when the pre-hearing conference is?
Your Honor, hold on just a second. I can give you a date. I believe that she has rescheduled it has not been rescheduled yet.
All right. Mr. Bacot, I suggest that you try and contact the prosecutor's office to see what they can do to proceed with this in a rapid fashion, but I can't do anything. You're not the legal father as of right now.
Yes, sir.
You can renotice or do whatever at a later time. All right.
Yes, sir.
Good luck. Thank you.
Thank you. Bye-bye.
Bye.
Thank you, Your Honor.
Thank you, Ms. Smith-Lowe. Nice seeing you. Have a great weekend.
Well, I just wanted to make sure that the court was aware that there was another hearing, Sorensen versus Rodriguez, and
that was adjourned, wasn't it?
That was adjourned, yes. Okay, I just wanted to make sure.
That was number 23 on my list, and I showed that's adjourned.
So, Strawberry Letter 23.
Pardon me?
Strawberry Letter 23, the Johnson brothers, the brothers Johnson. Since we were talking about Beatles number 9, Strawberry Letter 23.
I'm not familiar with that one.
Okay. All right. Have a good weekend. Thank you, Your Honor.
Thank you. Take care.
Bye-bye.
Both parties are present via Zoom. Mr. Hexel is present via Zoom. Mr. Browning, attorney representing Mr. Boyer, is present in the courtroom. You should be able to see him. through, our services here. And as I say, Mr. Hexel is representing Ms. Greening. This is the plaintiff. Ms. Greening's miscellaneous motion, but what she's really saying is she wants dad's parenting time suspended or have it supervised. Our family wizard, she wants, and she wants the counseling and whatnot for the child. I'll start out and talk about, there's something that Mr. Boyer has objected to the entry of the friend of the court report and recommendation. Mr. Browning, what's going on with this? Because no objection was filed.
Well, Your Honor, we filed something in response to this particular motion, Your Honor. And of course, we did have we did file something to be heard on September 20th, but what we have filed today is entirely different than, and it is not in relation to the report or recommendation, except insofar as Mr. Hexel's motion that we're being heard today mischaracterizes and misunderstands the report and recommendation in part.
Well, I mean, the report and recommendation was entered because no objection was filed by either party.
Right.
End of story.
But this isn't our hearing. This is Mr. Hexel and Mrs. Greening's hearing.
Yeah.
Yes. And our
All right.
response to that.
All right, fine. Mr. Hexel, what do you have to say about your motion?
Your Honor, we were here a couple weeks ago or a month or so ago about this matter. There was an order from yourself that there was to be no interference with the phone. We filed an ex parte. Judge Gardner said no interference with the phone. We were here last time. You said if you heard that there was more interference with the phone, if there was communication with the child regarding this matter or about Ms. Greening herself, that you would suspend his parenting time. Even since the front of the court recommendation and order, these things continue. The child comes home and reports to her professionals, to her mom, that these things are still going on. They're having a negative impact on her. She's being put in the middle. She has ADHD. She has anxiety. All of this stuff has a long-lasting effect on her. Mr. Boyer just simply doesn't understand that his actions are impacting his daughter. The court has ordered that we seek counseling. Mr. Browning was to prepare the order. That order was never prepared. So I'm asking the court today to enter the order for the counseling, that there won't be interference with the phone, that he won't talk about the case or Ms. Greening, to enforce that order and make it clear to him that this is serious by reducing his parenting time until we can get this counseling in place so that this child can be protected. In the meantime, too, we're asking that Mr. Browning and Ms. Greening use our family wizard to communicate. He sends her multiple text messages a day. It interferes with her work. We just need one place where the questions can be asked and answered.
Mr. Browning, let's start out with the easy one. Why object to our family wizard?
Well, we haven't objected to our family wizard, and I don't think that my client would object to a co-parenting app.
All right, then we'll order our family wizard. Each party will pay their own part. Yeah. As far as his other things, what do you have to say? Because there is clear, even in one of his text messages, if you will, he basically is saying, I can do what I want with that phone.
Your Honor,
and I'm tired of it.
Yes, Your Honor, I believe Mr.
More than tired of it. Go ahead. Go ahead.
Okay, I'm sorry, Your Honor. I believe Mr. Hexel has misstated the timeline. You told us that he was to stay away from the phone back in June. Yes, he did. Yes, you did. However, the kind of the report and recommendation, once it says something different, then allows him to at least monitor the phone like a normal.
Is it in an order of the friend of the court?
Yes, because we didn't timely object to it. So then it's.
And you see.
And also it's, as I stated, page 6, paragraph 6.
That's in the report. That's not in the order.
So
is it in the order? Is it in the order? The court speaks through its orders, not its, background and all this kind of stuff. It's in the court order. Can you show me in the court order where it says he can mess around with her phone? It does stuff like transportation, other parenting, summer exchanges, will not use substances or alcohol 12 hours before both parents written. I don't see anything in the court order about him being able to do anything with the phone. The court order is what I deal with, I don't even read the report and recommendation. I get the order.
Okay. Well, I didn't realize that the report and recommendation specifically excised the portion that says that only the parents were allowed to monitor the child's phone behavior. I could use to have a copy of the report and recommendation or the.
I don't care what the report and recommendation says. The court order doesn't say anything in there about it. And the last thing that I said is he's not to mess with the phone. And quite frankly, that order hasn't been entered yet, but there was something said about that. At that, we don't have an order from the prior order that I made, correct?
That's correct, and that's what I'm asking for today.
Well,
I filed a motion to enter because Mr. Browning didn't prepare the recommendation order after the last hearing.
and so do you have the proposed order here?
I think it was attached. The only point of clarification is that that does have the parenting time from the last referee recommendation. I think we just need to clarify that the front of the court recommendation order is the current order of the court. Because this would enter subsequent to that.
Right. And you're asking for the order that you have the entitled referee recommendation and order. 3 pages, right?
Correct.
Says, now therefore is recommended that the court enter the order as follows. The order dated through May 13 is set aside and defendant's counsel shall resubmit it as a referee recommendation order. Shall have parenting time every Saturday and Wednesday parenting time pending court order report and recommendation, which is pending. Neither party shall discuss the case with the other, and the parties will cooperate setting up therapy. That's all it says. Doesn't even say anything about the phone in there. Right?
I must have overlooked that, Your Honor, but we can clarify that today as well.
All right. So, counsel, I mean, are you telling me that I didn't tell him to quit messing with her phone?
No, Your Honor, I am telling you that we were under the impression that the report and recommendation, since it was not objected to, was entered in its entirety, and we may have made a mistake thinking that the portion that says that the parties alone will correct, monitor, and discipline HB's behaviors and phone activities without any third parties. Okay, well, he can stop immediately. I did not, I sent him this, obviously, and that is why he thought he was now, with all the other restrictions that this report and recommendation put on him, cut his parenting time way back. He's been complying with that. And while we haven't successfully set up the counseling, he has been attempting, despite what the legal counsel says, to do that. He has not received cooperation from the opposing party. He has not had the child insurance card, which is necessary. He does have an appointment set up finally for this Saturday, if, in other words, tomorrow, if he can get the insurance information from Ms. Greening. And that would be with, as he said, Forest Hills Therapy Center, with Rhonda Densborn. Your Honor, my client is not trying to ignore the court's orders. He honestly thought that he was now at the court, and the FLC investigator, who was pretty harsh on him otherwise, at least allowed that he and not his spouse would be allowed to monitor. I mean, she's 11. You know, he's not.
You know, and what I'm saying is, I'm not saying that he could not look at the phone to see if there is something, if she's involved in some kind of bad conversation somewhere. Okay. I'm not saying that he can't look at it. All right. I'm saying he can't take it from her. I'm saying he can't, he's using it as discipline and stuff. She's got to be able to have her phone. I know she's only 11 and I don't know when,
He's
but,
not doing those things anymore. He has not done anything like that since. Just that the opposing party is alleging that he isn't supposed to touch the phone whatsoever.
Mr. Hexel, are you saying he's not allowed to touch the phone?
I don't think that that's what you said. I think you said he's not allowed to interfere with the phone.
Right.
He's using the phone to go through it and take it away from her. It's caused intimidation.
That's what I'm saying. He can't, but every parent should have the right to look at, to make sure she's doing something appropriate. If she's sitting in the back seat on it, I don't know what she's doing, and mom doesn't know what she's doing. Maybe she's texting some guy who turns out to be 40 years old and he's trying to groom her. I mean, that's one thing. All right. It's another. And if he found that that was the case, he should contact Miss Greening and say, whoa, we got a problem here. Okay. And that's the only thing he's there for. He's not there to take the phone away from her and all that. That's what was being done before, as I understood it, is, looking through it, and it's not any problem if she's texting her mom or all this kind of stuff. It really is not this difficult to do. Quit using her phone as some kind of a weapon against the child. And that was not entered as an order. So, Mr. Boyer, that just because I get all kinds of stuff, it's a 10-page document stating things, it's a 3-page document of an order. No objection was made to the order. All right. By either party. So that governs right now as far as what type of parenting time you get. You get Wednesday from 4 to 7 and alternating Saturdays from 1 to 7. All right. That's basically, and talks about some holidays and stuff like that. Neither party objected to it. So that's entered. So what else? Counseling for the child. Well, have we agreed on a counselor?
We have not, Your Honor. We've proposed Fountain Hill, anyone at Fountain Hill, Ben Burgess, anyone who's used to these kind of cases. Mr. Boyer accuses Ms. Green of alienating. It would be best that we have someone who's, used to that, used to the court process, who can dig in and deal with this stuff. So we proposed anyone at Fountain Hill, essentially.
And he proposes somebody else. Number one, why, if she has an insurance card and stuff like that, why doesn't he have access to it?
My understanding is she's provided him the information that he needs.
Why, I mean, isn't there a card you've got that for insurance?
Hannah, do you have a card?
Yes. It was originally asked that I provide that so that they could have Zoom family counseling. And that wasn't something that I agreed to and wasn't something that was ordered by the
I don't
court. So
care. He
didn't-
gets the insurance information.
Okay.
Period. You get it to Mr. Hexel. Now you can make a copy of the card. I don't care what. All right. We're going to get to the next section of who's going to counsel. All right. He's proposed somebody this Saturday. Do you have any idea who that is? Have you provided that to opposing counsel at all?
Well, I just received this, but Mr. Boyer has been trying to communicate with Ms. Greening as to.
Well, they don't communicate very well because we know that we got to do our family wizard. All right. So I got two counsel here who should be able to figure this out. And it doesn't necessarily, the counseling doesn't necessarily have to be on his parenting time only. All right. He doesn't get very much parenting time. And I'm not saying he has to have it on a Saturday, because that's going to extremely limit who we can even have there. There aren't many counselors that are going to be working on Saturday or Wednesday night. The hours, Mr. Hexel, what do you say? You've proposed somebody, Mr. Browning. What is wrong with somebody they proposed?
Well, just Your Honor, it wasn't so much that there was anything wrong with them, but Mr. Boyer was in the process of trying to arrange counseling, and now he has. I think that's Forest Hills Therapy Center. I don't think there's anything wrong. The appointment is all set if we can just get Hannah's insurance card.
You'll have her insurance card promptly, but what? You got to provide some information. I don't have any idea who this counselor is. Do they work with adolescents? Do they? What is the counselor? Do they work with family reunification? Do they? I don't know what they specialize in. Do they specialize in drug counseling? I don't know.
Okay, we can provide that information, or if Mr. Boyer has that at hand, if he could be permitted to speak about his counselor that he's located.
Yeah, I'm waiting for you to provide that information.
Unmute yourself.
If I may, Your Honor, the first time I heard about this specific Fountain Hills counselor was through that order. I had been trying to schedule therapy with Hazel for the last month or more without cooperation from Hannah.
This isn't helpful. I'm asking you what your counselor supposedly is that you got a counseling appointment with.
All right. Yeah, the counselor is Rhonda at Forest Hills, and she specializes in family therapy and cases like this.
Rhonda, that's her only name?
I have her last name.
It's Densmore.
Rhonda Densmore, yes.
Densmore?
Yes, sir.
Densborn. S-B-O-R-N.
B-O-R-N-D.
No, sorry.
Mr. Hexel, you and your client can look into it. Do you have a problem if she goes this Saturday to there?
This is the first that I've had an opportunity to do any research on her. I don't know anything about her. Briefly looking online, it looks like she does individual, family, and marital counseling. I think here we need someone who does more of a rehabilitative approach for Mr. Boyer and Hazel. I can look into it more and talk to Mr. Browning, but I think Fountain Hill is going to be a better service to do what we need to do in this case.
Not necessarily. Fountain Hill is pretty expensive too, but okay. I'm going to tell you, the two attorneys got a week to figure out where the counselor is going to be. Okay. If you can't agree on it, you'll each submit a couple names in here and I'll pick. If you can't agree, I'm not going to keep going on and on and on about picking a counselor. Some of it, Mr. Boyer should get a little bit of deference in it because it's to try and he's got the problem. Okay. And he's going to have a big say in where he wants to go to counseling as long as it's appropriate. If it's a marital counselor, doesn't help out a lot. It's more of a reunification type of counselor to deal with the child. The attorneys will exchange their names, talk, whatever. In a week, if you can't come up with it, you'll submit 2 names to me from each of you. Reasons why the other person's names aren't appropriate, or what. And I guess I'll just randomly pick because I don't know what else to do. And if Mr. Boyer's are appropriate from a certain, I mean, they deal with reunification and stuff like that, I'm likely to go with his because, as I say, this is his problem that he's dealing with. All right. And you obviously got to get along. But if the counselor isn't going to help you, then you ought to look at some other counselor. So that'll be the order, is that first of all, we're going to do our family wizard. Second, parties will figure out a counselor over the next week. If they can't, they'll submit names to me and I'll pick it. Third, there's to be no interference with the child's phone. All right. You understand what I mean? That does not mean you can't look at it. It means you can't take it, at least at this time. You can't take it away and that kind of stuff. Right. Anything else that I need to address at this point? I'm not.
Your Honor.
What?
Then neither party will discuss this proceeding and neither party will discuss the other party.
If I find out, Mr. Boyer, that you are discussing this, because it's pretty clear that the psychiatrist or psychologist that is talking to this child says you are, and I don't know how much else I can say other than if you don't stop it, I'm not going to let you see the child. End of story. You will see the child at Journeys 1 hour a week. All right. So if I get some counselor saying that, oh, the girl comes in and is talking about all this and that kind of stuff, I'm going to listen to the counselor and I'm going to stop it. I'm just tired of it. Miss Greening is not the enemy. I know you think she is, but she's not. She's the mother. All right. I don't care what she did in the past, and she's not to beat up on you. Miss Greening, this goes for you too. I don't know if you're a saint or not, but very few saints come in front of me. So I'm just telling you, nobody, I don't know how much firmer I can say it. I am just sick of this stuff, and I'm going to stop your parenting time if I get any type of valid information that you are discussing this with the 11-year-old child. Doesn't seem like you can help yourself from doing it. And then we'll tell her, don't tell anybody about this. She's going to be going to counselors and she's going to be dealing with them. And I hope she opens up. And if she tells anybody that, I can't tell you stuff because my dad says no, I'm going to listen to the counselor. I'm going to stop your parenting time. You're going to visit 1 hour a week at a supervised location. Who's going to draft this order? And can we get the order in here now?
I will draft it and I'll get it to the court today.
Do you care if we enter this other order?
Yeah, I can just condense it all into one.
All right, condense it all into one, send it promptly to Mr. Browning. You need to deal with it promptly, okay? If you have objection, talk to Mr. Hexel right away. All right, I got to get these orders entered. The parenting time order dictates the parenting time right now from the friend of the court because nobody objected to it. Anything else, Mr. Hexel?
Nothing further, Your Honor.
Mr. Browning.
1 point. It's clear that Ms. Greening is talking about the proceedings with the child because
I just told her she better not either, because if I get that information, what do you want me to do? I've been so straightforward. I don't know what else you want.
Thank you, Your Honor.
All right, Mr. Hexel, see if you can get that. I know you're a busy man, but see if you can get that to him promptly. Miss Greening, get a copy of your insurance card or whatever to your counsel right away. You can probably email it to him or fax it to him or something so that he can provide it to Mr. Browning. I would like it done today if possible. All right.
We'll do, Your Honor.
Question, should the counseling appointment for tomorrow at Forest Hills be kept?
I mean, I don't really care. Okay. Do you care? I mean, it's not like she's going to get hurt there. That may not be where she ends up going. All right. And it's on his parenting time.
Yeah. I have no objection to that as long as it doesn't.
I mean, there's no objection to it. Maybe he won't want to, because I don't know that that's going to be the final counselor either. We'll figure that out. I mean, if you want to take her to counseling tomorrow, have at it, I guess. But I don't know that it's in, you figure it out. Anything else? Okay. Nothing else from council? Thank you both very much. We're adjourned.
Thank you, Your Honor.
Thank you.
Are you ready to go on minutes?
I am.
Everybody out there in YouTube land, hello, especially to Cheryl and Misty and Sharon, if you're on. It's, we're all happy about the continued improvement with Dan. That's a big part. Good luck, everybody. Thank you. All right. We're waiting for her to connect. You say you got some kind of settlement?
I think so, Your Honor.
It wasn't even a motion that looked like it was going to need a settlement, but good luck. Thank you. Put on your camera and take off your mute.
Sorry. Yeah, I got it.
Oh, that's fine.
Yeah, come here. Trying to figure out the buttons. My bad.
I can hear you. We're here in the case of Mitz v. Wiersma. We have both present on Zoom. We also have Mr. Hexel, Mr. Wiersma's, Mr. Mitz's attorney. There's a motion filed by the defendant, wants the judge to oversee the case. Mr. Hexel, you have any comment about this or what?
Your Honor, we've been discussing this, and I think the parties are in agreement that they would like to adjourn the trial that's scheduled and attempt some ADR, going to FOC for mediation, and then report and recommendation if mediation fails. So if the court could assist us in getting to those processes, that would be greatly appreciated. And I think both of these parents want to avoid the impact of a trial.
So there's one scheduled for October 7th, right?
Correct.
And you want me to refer this to mediation, that you're gonna draft an order allowing it to go to mediation?
Yes, and then if we can also get a referral to FOC in case mediation fails for report and recommendation.
Who's gonna pay? I mean, is it just for a parenting time?
Custody and parenting time, yeah.
Well, that's I can't do custody unless I find proper cause change of circumstance. I can't send it to him. If
Well,
it's
I think
parenting time, I can send it to him.
okay. In our previous hearing, I think we did, but because our custody trial is scheduled for the 6th, it's custody parenting time.
All right. Ma'am, is that your understanding? You want it to go to the, referred to the friend of the court if you cannot reach an agreement at some type of mediation? Who's going to mediate this?
We're going to contact the FOC to see if they have availability. Otherwise, I think a backup could be Dispute Resolution Center. They've used them in the past.
Ma'am, is that what you're agreeing to?
Yes.
All right, then we will refer this to mediation. You can indicate through the friend of the court, or if that isn't available in a timely manner, through the Alternative Dispute Resolution Center. If mediation fails, you'll have to contact me and we'll make a referral to the friend of the court for them to do a report and recommendation. I'm not going to send it there unless mediation fails. Parties, it's $150 from each party to refer it to the friend of the court. If that happens, ma'am, you understand that?
I understand. I'll figure it out.
It's $300 total, and I always divide it in half. All right. But that won't come up unless and until you don't get a mediated settlement. So that'll be a while from now. I don't want to refer it there unless mediation fails. All right. We'll also then take off the October 7 trial, and I'm not going to set a new date for it because by the time you guys mediate and by the time you go to the friend of the court, ma'am, if it goes to the friend of the court, they will make a report and recommendation or what they believe is appropriate. If you don't object to it in a timely manner, it will be entered as an order. I'm just giving you this information ahead of time so you understand this. All right? You understand it, ma'am?
Yes.
All right. Mr. Hexel, you'll draft the order for the mediation. If it comes to the time where we need to send it to the friend of the court, we will need to do a referral. You can make sure you get something to us indicating that, we need the referral. Make sure Ms. Wiersma gets a copy of it. All right. And then I'll actually make the referral. Do you understand how we're doing this, ma'am?
Yes.
All right. Okay. You'll draft the order. Thank you. Good luck.
Thank you. Have a good weekend.
You too. Thank you.
Ooh. Okay, I'm done. Am I good to go, sir?
What?
Yes.
What?
Uh-oh.
What I do?
There's two smiling people that I see. Mr. Van Elderen and Ms. Striegel.
Yes.
Happy faces if I've ever seen them. All right, Emily Brown is connecting. Is Mr. Castanos connecting?
He is not, Your Honor. I don't understand precisely why we're here exactly. I've instructed him not to attend because we're here on what was initially.
All I want to know is he
He's
going to
not.
here? And you said it's fine that he doesn't. Okay, that's fine. Miss Brown is connecting. I think 6DS Brown v. Castanos. Ms. Brown is connecting. I hope on Zoom. We have both attorneys already present. Ms. Brown, are you connected here? If so, unmute so we can hear and see you, please. Did it show she was connected?
She's on.
All right. Can you hear me now?
Yes.
All right. Ms. Brown is now connected. This is a motion that was filed by the plaintiff, an objection to entry of a proposed order from 7/26. Have you guys figured any of this out? It looks like there's no longer an objection to the proposed order and stuff like that. Is that correct, Mr. Van Elderen?
That is correct. And frankly, I'm a little confused as to why we're here today, given the fact that the only thing Ms. Striegel filed on August 2nd was an objection to the entry of the referee's recommended order, and she's now withdrawn that objection. It appears as though in her submission of the withdrawal of her objection to the court on August 29th, she raises some additional issues that she intends to have addressed here. But I would argue that given the fact that she's withdrawn her objection, she's not filed a separate motion for those issues.
All right. So I'm going to sign that order that he has provided. Is that correct, Ms. Striegel?
Yes, it is. My understanding, I just want to quickly explain. My understanding is we needed a stipulation to withdraw that objection. And when Mr. Van Elderen we did not receive the signed stip. And so we went forward just to let the court know they're actually exercising parenting time, but it's on a different day because of the kids.
I just got to enter the order.
Okay.
All right. I'll enter the order if people are going to try and change stuff. God forbid you'll be back in front of me trying to change stuff, or you can get a agreement through Mr. Van Elderen. Don't know, but I believe I'm just going to enter the order because there is no longer an objection to it. Is this the one? I'm just trying to make sure I enter the correct one that you've sent with me. Miscellaneous, got not to discuss, parties not to discuss, removal of Michigan. Is this one you're talking about? Oh, no, this one's prepared by Ms. Striegel. What is do I have the one that you prepared, Mr. Van Elderen?
I think, let me look back at myself, because I know that Ms. Striegel's office provided me with an order that we did not, that satisfied all the issues and the objections. And
I have an original here from you.
Okay.
Original.
Let me pull up the order.
I didn't hear a response back. So that's why we're here.
Okay. I thought that I apologize. I thought that I had signed and sent that we had signed and sent that back. So let me back.
It starts out on page 2 that says temporary parenting time right at the top. Defendant shall have parenting time with the minor children of the parties every Wednesday from 10 a.m. to 6 p.m. Once school starts, the defendant shall have parenting time every Wednesday after school until 7 p.m. Is this the one I'm entering?
No, I think the one that we're entering is there's you do have one you said that was prepared by Ms. Striegel?
There's one prepared by Ms. Striegel and there's one prepared by you.
Okay, so the one prepared by Ms. Striegel, I believe, paragraph 2 says until further report, defendant shall have parenting time with the minor children as follows: 1 weekday from 10 a.m. to 6 p.m. during the summer, 1 weekday after school until 7 p.m. during school.
Hold on.
Alternatively, we could just sign one and submit it to the court so we make sure we have the correct order.
Yeah, why don't you just submit?
Yeah, we'll just do that because I have the correct one. I apologize, Ms. Striegel. I was confused as to why Ms.
Yeah, that's the only, because I didn't hear back.
But okay, so I just want to make sure. I apologize. I didn't realize we hadn't sent that back. I thought that we did, but I think in the hubbub of the holiday weekend and everything, it probably
Two of you can sign one for entry and send it to me.
Sure.
Soon. I'll sign it.
Okay.
Okay.
Sounds great. We'll get that.
Sounds
We'll get
good.
that for the day. Beth, I'll get that over to you today.
Thank you. Take care.
Okay, thanks, referee. Have a good weekend.
Bye.
You too. Bernice versus Bernice.
Good morning. That's close. Barons.
What is it?
Barons. You're close.
Barons.
Yep.
Barons versus Barons. Both parties are present via Zoom. This is a motion filed by the plaintiff to find that a child was born out of wedlock, that being Scarlett. The parties have been divorced for a period of time. Apparently, at the time of the divorce, she was pregnant and maybe didn't even know it. So that when the court, I'm assuming the court asked if you were pregnant, probably said no. And now has filed a ROPA motion to find that Scarlett is not an issue of the marriage, because as of now, technically, defendant would be the legal father. Am I correct in what I've said, ma'am?
Yeah, somewhat. I became pregnant maybe within like a week after the divorce was final. And then she was born early. She was born about a month early.
So how do we, I mean, if you became pregnant after you were divorced, then this isn't a question. Who's making it a question?
Child support, the front of the court, child support said that because the law in Michigan, I guess, states if a child is born within 10 months of a divorce, that the child legally belongs to the ex-husband, apparently.
Never heard that, but all I can really do at this point is order a quick DNA test. Will you guys just cooperate, please? Do a DNA test. Get it to me when it comes through that you're not the father. We'll meet back here, you file a motion, and I'll find that you're not the father. Cooperate with it.
Where would we do a DNA test?
We'll get you an order. I don't know where exactly it is to go. I'm trying to think where we've had others. You can probably contact the civil division of the Kent County Prosecutor's Office. That's where they send people, and ask them where they go to get that. I have to have a DNA test to show that he's not the father. And we do it all the time. I don't send people to a direct place. I just tell them they got to get a DNA test, but it can't be one from home or something, because who knows who did it. Okay. We have to have some kind of a facility do it. There'll be a cost, ma'am. It's going to be your cost at this point. If it comes back that he's the father, then I'll make it his cost, but
it won't.
I'm sure it won't. I'm sorry I have to go through this, but the law says I shall enter that on there. So let's just get it done. Get done in a hurry, submit the report to me, and renotice this. Just renotice it when you get it back. And we'll have both of you on. I'll ask you if you've had any relationship with the child or whatnot. No, and I'll probably find then the child's born out of wedlock and not.
Okay. So when we get the DNA test done and we get the results, then I have to submit those to the court when I file the new motion.
Yeah, and like I say, you don't even have to file a new motion. If you I'm trying to save you money, okay?
Sure.
You'd have to, the motion would have to be filed, and it'd cost you, okay? So just renotice this motion and set it and send in the appropriate DNA test.
Okay, and sorry, I have another question, because that DNA test could be done at like a diagnostic center.
I'm sure that it can.
Okay.
I have to have somebody who knows that in fact, he showed up and he gave a DNA test, okay?
Yeah, so it's not like a home DNA test, I got you.
Yeah, because you could get it from anybody, get it from the dog and do the DNA test, and I wouldn't know.
Yeah.
Or sorry, you gotta go through this. It'll be the last thing. Hopefully you have to go through in this. All you guys have kids together, so you still get along. I don't know if you get along, but you still have to do this. Good luck. Okay, we'll send you out an order to both of you for the DNA test, and just get it done and be over with it. Good luck. Thank you. 40-DS. Father's motion for custody is what he's asking for. I've set up other hearing dates for custody, the latest 6/15, but you didn't show up for that one. So we dismissed a prior request for custody. There still is not a court determination for custody, so I have to set up a hearing. However, and I will say that plaintiff is not present. I assume you gave her a copy of this motion at some point?
Yes, sir.
How'd you do it? Hand it to her?
Through
Through the mail?
Yes.
All right. You think she got it? I mean.
Yes, since the date that I believe she has got it, since then, I have not been able to talk to Kyrie. So.
All right. Well, here's the biggest problem. All right. I know there is currently an NA case, an abuse and neglect case. All right. That is pending. It is in front of Judge Hillary. I have the case here in Kyrie. There's 4 kids in the NA case. They were removed from her care at one point. You were not a respondent to that case. So the child, Kyrie, was given to you and has been with you for some period of time. Looks like the latest order from July returned Kyrie to mother. That's through the NA case. I'm not sure the exact date that the child was returned, but the child was returned to mother. I don't know if you have any other orders in this case, but number one, I can't overturn what the NA case does. You have to understand that. I can't overturn it. That case controls right now, okay? And I just can't do it. You're asking for custody. I wish you would have shown up on 6/15 because you probably had the child.
Can I explain why I didn't show up?
It doesn't really matter though, because you didn't show up and you
It
did
kind
have
of
the
does
custody.
because I reached out to your secretary and the court date was changed based off of something that happened with you, and which is understandable. But the date that it was switched to, I had an incident with myself, and I explained that to your secretary, and I don't know what happened with with communication, but she told me to file a complaint.
It really doesn't matter because it was over a year ago and nothing's been brought up since then. Okay, so I'm just telling you, I have to have a custody hearing because custody has not been determined by the court at this point. It was through a DS case, and that says in the DS case, and that's why we were scheduling the first time, is basically the initial custody is given to the mother, initial custody of the child is given to the petitioner mother without prejudice to the determination of either parent's custodial rights until otherwise determined by the court or agreed by the parties. There's been no agreement by the parties. I have to have a custody hearing. I'll set up a custody hearing on this. I'm just telling you that no matter what I do at the time, the NA case will tell where and when custody will be until that case is dismissed. It's just the way the law goes, all right?
They're the ones who asked me, who told me to do this, go through with this. So.
Who was?
The judge and the agency that's working with the case.
Okay, I'm telling you, I'm going to set up the hearing. I'm just explaining some of the stuff that I can and can't do. I can make a determination of custody. But even if I were to say you have full custody, and parenting time doesn't go to mom, she doesn't get any parenting time except 1 hour a week, it wouldn't matter because as long as the NA case is open, the NA case places the kid with mom, and that's where the child has to be. Okay. Now, sooner or later, the NA case, I assume mother has worked a treatment plan, and that's how she got the child back. That's all I can say.
Honestly, she got the child back because they were being extremely unfair.
Well,
they lied on me in court and all type of stuff.
I'm just saying she's got it back. I can't determine that. All I know is Judge Hillary returned the child to mother. Okay, so that's what happened. So we may have to deal with this somewhere down the road. We'll give you a custody hearing when we have a time available. You're going to have to look and read at what we send you because it requires certain things for you to do, like file a trial brief and stuff like this. So that exchange witnesses. If you haven't exchanged witnesses and you bring in a witness, you can't have that person testify. If you bring in exhibits and you haven't exchanged them prior to the trial, you can't put them in, right? I'm just warning you so that you read what is there and don't come in and just say, what? You don't have an attorney. Was it Roman Kosoric represents all the fathers at one point?
Yes.
Does he represent you still?
Roman, Mr. Kosoric does not communicate with me. I've reached out to him plenty of times.
I'm asking you, I think he's still appointed to represent you, isn't he? I'm not sure because you're not a respondent, okay?
Yes.
The only reason I'm telling you some of that is because I'm trying to tell you, you should get some assistance on the custody trial. Because I'm sorry to say this, but I don't think you know what you're doing with it, right? I know you're going to come in and say, I want it because I've had the kid and this kind of stuff. There's certain.
I have plans on getting an attorney by the next hearing.
You have plans of hiring somebody?
Yes.
Oh, you have no idea how great that would be. All right. For you. All right. I really hope you can do that. All right. So look at the stuff we send you. It's not going to be a hearing really quick because I got to have a half a day and we're booked out till November or beyond that. So we'll get it to you as quick as we can and we'll see you in court when you have that hearing. Okay.
Okay.
Good luck. Thank you. Number what? 10?
Hello?
Hello?
Yes.
All right. Mr. Carvajal, you can hear me all right, I take it?
Yeah, and I have the guide translator.
What?
I have the guide translator.
A translator?
Yeah.
Did you ask for one?
Yes.
Where did you ask for one?
When I have it like sign the paper.
Who did you ask it of? Because we don't have one here for you.
Is give me the schedule for today.
Yeah, but I don't think you made a formal request to people.
They say the guy is have it ready for today. I don't know.
Well, you apparently didn't communicate it to somebody because we don't have a translator for you here.
What's the plan?
There's nobody on for your case. We've had an interpreter for earlier. We'll either have to adjourn this or do something because we don't have an interpreter. You need to fill out the form for an interpreter. We'll renotice this, and probably for about 4 to 6 weeks, we'll renotice it so we can get an interpreter for you.
Okay.
What? You'll have to renotice this and fill out a form for an interpreter that's provided.
Okay.
All right. Ma'am, do you need an interpreter? Miss Gonzalez or Miss Rosales, do you need an interpreter?
No, I don't.
All right. You understand it's going to be adjourned because he needs an interpreter and didn't fill out a form for one.
That was the last time it was the same problem. So am I going to be having the same problem every time, or?
You know, it's not in my hands, basically. If he doesn't have an interpreter next time, if he hasn't filled out the appropriate form, I'll just dismiss the matter.
Okay, sounds good.
Okay?
All right.
You have to set it and fill out the form. It's got to be at least 4 to 6 weeks from now, because I'm not here 2 weeks from now. Good luck. Thank you.
Thank you.
See, matter of Pethers versus Carr. Both parties are present on Zoom. This is a motion filed by the mother regarding parenting time. Basically, the prior order prohibits the father from drinking 12 hours before and during parenting time and the complete anger management. It's pretty apparent to me that the father has been drinking during some of the parenting time, and she's now asking for some type of relief for the children and prevent them from drinking. Is that a short story of what it is?
Yes.
Sir, what's your response?
I don't believe in the allegations. I don't see any facts here. There's nothing to base this
Are you
off
saying
of.
that the kids are lying and that the kids were there and have seen you intoxicated?
I think that we should ask the kids, yes.
You think we should ask the kids?
Correct.
Well, it sounds to me like I've got a lot of stuff here and did you complete the anger management?
No, I have not.
Why not?
Well, I've done rehab, and I think that should satisfy the court.
Does it say in the court order you had to complete anger management? Is that your just decision that not to do it?
No, to be honest, I just forgot about it.
All right, ma'am, what else do you want to say?
I just worry about the best interest of my children. They have seen and heard way too much, and I do have witnesses to prove my case.
Yeah, can you tell me who are some of the people? I mean, I look at it. You've got a pretty detailed statement here, and I'll tell you right now, I kind of believe your statement that he's drinking. He just plain ignored the anger management because I just forgot about it, and it just doesn't fly. So I'm tempted to order some type of supervised parenting time in the meantime until we can get to the bottom of it. We can set up a hearing or something in the near future, but I'm tempted to supervise at this point for a period of time. Is there somebody available to provide supervision? These are young kids, 5 and 6.
They are 6 and 7 now, sir.
Okay, all right.
But who would you prefer?
Well, what about this? What about if you just, the kids, once a week, pick a restaurant and Mr. Feathers can meet with them there for a dinner or something I don't care when, every Wednesday, every Saturday for an hour or two, go to the food court at the mall or something like that. You know, it's unlikely he's going to be drunk at the mall, or at Denny's or McDonald's or whatever. I want him to see the kids every week, but
I think that would be good too. I mean, I'm the only one giving these kids a childhood. I mean, you can dictate my life as much as you like. You can go for it. I've been down this road before.
So, ma'am, can you think of a place that be good for the kids to go to see them for an hour and a half or something each week?
I guess
The kids like the mall. Yeah, that'd probably be good. A place you never take them.
So you're not helping your case at all, I'm telling you. Just
You're not helping these children's lives either.
You're not helping them being drunk. So I'm not
Allegations.
telling you, you're not helping them by following court orders. So whatever you want to say, I'm giving you fair warning. I'm the one who's going to make a decision on this, and you're not helping your case. So I'm giving you fair warning. How about the food court at, I don't know, Rivertown or Woodland on Saturdays at noon or whatever? Pick a place and time. Ma'am?
Sir, I was wondering if we could still do the meetups at the police station, because I just feel like this is gonna worsen our interaction when we see each other.
Where are you saying it is?
At the it's in Caledonia at the police station. That's our previous meet spot.
What's there?
The police station. And when we first started this court hearing, Ryan used to live right down the road from there. So that's why it was the mutual spot to meet.
What's at the PlayStation? I'm not familiar with it.
The police station, just for protection for me, because he has been abusive in the past and is.
What's at the PlayStation for the kids? If I'm having him see the kids for an hour and a half at the
No, I'm asking just to meet there, and then he can go to the mall from there. I'm just asking for a meet spot there. For like the pickup drop off.
So why can't you drop them off at the mall?
I guess I could, but I don't want to be in any contact with Ryan.
You got kids together. Do you have a PPO against them?
I do not, but I have filed for one in Florida, and it got dismissed because I was coerced into declining.
Well, gotta process the bear. All I'm telling you is what time on Saturday, if he's causing you problem, they got security, they got people all over there, okay? You drop him off at the food court. If he's a jerk, you also got a phone. Just videotape him what he's doing. Bring it back to the court. What?
Last time I recorded anything, FOC told me I'm not the police and I'm not supposed to record people. So
well, I'm telling you, if he's being a jerk and you record it, bring it in front of me. All right? But I'm just saying, just what time does Saturday at noon? What?
Noon is perfect on Saturday.
Every Saturday at noon, from noon till 1:30?
Sounds good.
You'll drop the kids off. He'll be there at the food court. I mean, if he wants to wander around a little bit with the kids, he can do it, but he's not to leave the mall.
Okay.
All right, Woodland Mall, noon, starting tomorrow.
Okay.
Starting next Saturday, would that be all right? I got prior obligations.
That's fine. If you don't want to see him this week, that's fine. Starting next Saturday, noon. All right?
Thank you so much.
All right. Thank you. We're adjourned.
Thank you.
Good morning, Your Honor.
Good morning. How are you today?
It's a good day to be Friday, Your Honor.
You bet.
I'm hoping I'm fairly close to the court, end of the court, and hopefully.
I hope I'm nearing the end. My clerk has had enough of it for the day.
Good morning, Your Honor.
Good morning, Miss Early. How are you?
Good. Haven't seen you in a long time.
It's been 100 years. Well, you haven't aged 100
long.
years, but I sure as heck have. All right. So tell you that we have Miss Powers is connecting to us here right now.
Yeah, my client is next to me, Mr. Powers.
Oh, Powers v. Powers. We have Mr. Powers present with his attorney, Miss Erdley. We have Mr. Swears present for Miss Powers, and Miss Powers is connecting. I think. We've sent her a message.
I spoke with her a few minutes ago, Your Honor. We didn't have the technical issues, so I'm not sure what's going on now, but we are willing to proceed without Ms. Powers being able to connect if the court wishes to move forward.
We'll see if we can continue to get her on. This is your motion on behalf of her to enforce the judgment of divorce. In essence, the two things that I can really deal with right now are the payments for an automobile, a vehicle. He was supposed to pay, didn't pay for several months, the insurance or the car payments itself. It's clear he had to. Your request is $2628.13. Is that still the request?
Yes, Your Honor. And I would also briefly note, I've had some communication with counsel. I believe the issue with the photo albums is essentially resolved. We'll work out the logistics, but I don't believe that requires any action by the court. As well as the transfer of the Nissan Maxima. We've coordinated, there's some signature paperwork. My client signed what we believe is all the necessary paperwork at Michigan First Credit Union about 4 o'clock yesterday. So I don't believe that issue will require any additional work by the court. So that really just brings us down to the issue of the reimbursement on the automobile payments and the life insurance policies, and then obviously our request for fees.
So it's just reimbursement for the insurance and the car payments, or is it still the amount of 2628?
It is the same amount, Your Honor, and then we have not reached a resolution. I've reviewed Mr. Powers' response regarding the 2 life insurance policies, but I won't get ahead of myself.
Yeah, that's probably going to end up something unpleasant, like having a hearing, quite frankly. But as far as the others, counsel, you admit that he owes 2628, don't you?
Well, Your Honor, my understanding is that that's what the judgment said, and my client avers that Ms. Powers told him she would pay those, and she did. And that
Do you have anything in writing or anything like that?
no, he does not. He does not.
Well, I mean, maybe we can wait and get Ms. Powers on and ask her if she did that, but I don't think she'd file the motion if she felt like she was supposed to make payments, and there's nothing other than what's in there that says he owes that for the car.
Right, and the car is now refinanced in his name. That was all taken care of as of yesterday.
Yeah, and she made the payments when he was supposed to, and it's really clear in the judgment. He's supposed to be responsible.
Yeah, and I think part of it was he didn't fully appreciate or understand it until recently. It was between counsel. Anything more you want to add?
No.
Okay. And so the only issue other than that, as we see it, would be the life insurance policies related to the.
Well, I'm gonna tell you right now, he owes 2628.13, and he'll pay it within 7 days.
26.
Mr. Swears, that'll make your client whole?
Yes, Your Honor. The one thing I would additionally note, having reviewed counsel's response on behalf of Mr. Powers with regards to life insurance policies, I went back and checked the original financial disclosures and spoke with my client. These 2 policies were purchased in April of 1999 by my client's father to cover funeral expenses for her 2 brothers. He is getting very old, and we're frankly not expecting him to outlive her brothers. It was only transferred to the parties in April of 2021, at which point the cash out value of these parties was about $9,000. So really the situation here, we believe it was part of the global settlement. Even if there was some marital portion of the payment, it is incidental. And what's really unfortunate in this case is this isn't the first time we've had this issue. Back in August of 2023, Mr. Powers filed a request for spousal support, which on its first page included DHS's payments for the 2 older brothers.
This is going way beyond where I'm looking. My reading of the judgment said that if it's a overlooked part, bottom of page 4 to the top of page 5, if either party has failed either intentionally or unintentionally to disclose any of his or her assets and debts, the issue of property division may be reopened on the motion of either party to determine and resolve the distribution and any previous undisclosed assets. All I'm looking at is, it seems like it was not dealt with in the judgment. Is that? Here comes Ms. Powers, maybe.
Your Honor, can I respond on the?
Hold on a minute and see if Ms. Powers is finally here. Ms. Powers, can you hear me? You're on mute, so I can't hear you, but I saw you say yes, I think.
Yes, I can hear you.
All right, I've already gone through the enforcement of the money that's owed to you, 2628.13. Did you agree that you'd make those 3 payments? Those payments on the cars and stuff?
No.
All right. I've ordered him 7 days. He has to pay that amount.
And just so you know, Your Honor, my client indicates to me he cannot make that payment within 7 days.
He got $75,000 recently.
Which has all been used.
Which has all been used to pay various bills. And there are bills, marital bills that have not been paid by Ms. Powers that she still owes. We didn't file a motion in response to give all those, but we may have to file a motion as to some of those things. But I do want to address the life insurance policy. It sounds like you're
Hold on before I get there.
Okay.
How long has he got to have to pay? This is money that she shouldn't have had to pay. And I'm going to not give you forever to pay it. That's money that she is owed. If you want to file a motion that she owes somewhere, I don't care. But you owe that money. She didn't agree. She said to make those 3 months worth of payments. You'd think she did. Your counsel has told you correctly in that, I mean, unless you had something signed by her, you owed the money.
There is a 401k transfer that needs to take place where he'll get another large sum of money that's related to the settlement. And Ms. Powers needs to send information so the quadro and so forth can be done and the 401k can be transferred. So that's another issue in terms of money that my client is supposed to get in the settlement that she needs to sign off on so he can make payments like this one.
Mr. Swears.
Your Honor, I did just receive, my client has forwarded me over information from Attorney Jenny Johnson, who's been preparing the quadro, so we'll provide that shortly. But again, we just gave him $75,000. I don't know what he chose to spend it on. A 2019 Nissan Maxima wouldn't have required all that money.
Well, that's what I said. She got $75,000. Where'd you pay $75,000 to?
Various bills, lawyers' bills. I owed my parents. I had my own credit card debt. It does not go fast, or it goes quickly. I had medical bills to pay. Sorry, Your Honor.
Get your money from your credit card then to pay it. I'm not going to give you very long. You owe it. That's straightforward.
I'll be glad to pay it as soon as I get the 401k.
You'll be glad to give it. You'll be glad to pay it when I tell you got to pay it. All right, I'll give you to the end of the month. I'll give you till the 1st of October to pay it in full. And Mr. Swears, you're working with Jenny Johnson to get the 401k or whatever the quadros are that are being drafted. Is that my understanding?
I'm reviewing what additional information is needed, Your Honor. They're way better at quadros than I am, so I'm just going to assume that if I give them the last couple bits they need, it'll be done.
You'll work with Ms. Eardley to make sure that she has all the information proper so that she knows what's going on also.
Yes, Your Honor.
All right. All right, we've exhausted that. We don't have to deal with the photo album. Now we're dealing with the life insurance policies. Because of what I just read you, I'm interpreting this as a motion to reopen about those two insurance policies.
The only thing I would note, Your Honor, these were disclosed by both parties. They were listed on the verified financial information forms. They were discussed at mediation. Attorney Rick Rohn represented Mr. Powers, who is very capable. Mike Danton mediated, very capable. I was there. I'm not in their lead, but I don't believe this is a situation where they were undisclosed. This is a situation where, admittedly, the three of us should have included them listed there. It was the understanding of the parties that this was a dealt issue. And again, what we have is less than 2 years ago, our client's father, who had been paying these for 22 years, transferred the parties because he assumed he would not outlive his sons. And for Mr. Powers to now be sitting here and again, he's filed for the spousal support, asking for the state of Michigan money going to these two older gentlemen with Down syndrome to be paid to him as spousal support. It's not how we do this. And these two funeral policies are not intended for him. They're to benefit our client and her brothers, to basically just help her bury her brothers. I don't believe it's an issue of not disclosed. I believe, yes, it should have been more clearly drafted, and I will certainly share my share of the blame in that. But it's not an undisclosed asset. It was part of the global settlement. And this is not the first time that Mr. Powers has come back asking for money intended for the benefit of these two other gentlemen to be taken from them and given to him. So we just asked, I don't believe it's an undisclosed asset, Your Honor. And again, the value that increased during the marriage while this was assigned to the parties is incidental at most.
May I respond, Judge, because I haven't had my chance yet on the life insurance?
I'll give you your chance. Go ahead.
Thank you. I agree with you about the judgment. If it's not listed there as something that has to be reopened and assessed by the court, obviously my client and his now ex-wife were beneficiaries on the policies, so does a marital asset. And just my client wants to make sure that the court doesn't assume he's some kind of monster trying to profit off of two Down syndrome people. He was their backup guardian and guardian for 7 years. He took care of them and was with them 24 hours a day during the pandemic, 4 months before they separated. And payments for the policy came out of their joint account. We've got ACH withdrawal records going back in 2023. And these were all payments made
After we separate.
after the separation by my client. He's not asking for that money back.
What are the type of payments that you're talking about?
The monthly policy payments.
Monthly policy
I'm asking,
payments.
is it $10? Is it $300
I'm sorry.
a month or what?
It is approximately $80
a month?
Yes, between the two.
All right. Well, I'm not going to be able to. I'm not going to be able to figure this out on a Friday morning. I got matters that seem like I shouldn't have to deal with, but I'm going to have to set up some kind of a quick evidentiary hearing to deal with this. My mother is saying that her father paid for most of these, and had it. It was in his name, and he transferred it to you guys later on. So I just lost somebody. I lost her. But quite frankly, I'm going to have an evidentiary hearing and figure out if it's a joint marital asset. Oh, there you are up there in the corner. Joint marital asset, and if it is, what portion goes to who? We're not going to go outside of that. I'm not going to worry about whether he tried to get money from Social Security or whatever. we're just gonna bring in the documents on this. I'm gonna reserve attorney's fees on it because I'm concerned. I'm concerned that the motion was brought here and clearly he owes the 2628. I'm not buying the idea that he thought Mrs. Powers was gonna make those payments. I don't buy that. He may be responsible for that attorney's fees, but I don't want to deal with that until we get through everything. All right. Because in the end, I may have to have a hearing on that because the Court of Appeals tells me I have to. She
Yes, I understand.
says that in fact, she doesn't disagree with the amount that you are charging, but she disagrees with the amount of hours. So I'd have to have a hearing on that. And then, of course, if you win on that, he could have to pay for the whole hearing too on that. You know, because if I find that you have submitted a reasonable amount and we have a hearing and I find that that's reasonable, he'll be responsible for prep and everything for the evidentiary hearing for the attorney's fees.
You understand?
So many things that people should be trying to figure out, but what I'm going to do is set up, I think, a like 1 hour evidentiary hearing on this. I think it's mostly going to be documentation that people are going to have to submit. I will try and meet with, I'd like to set up a settlement conference as soon as parties can get their documents together to meet with me and see if we can't figure this out without a hearing, but if we can't, we can't. I can't make a ruling on it here today. So the order will be 26/28/13 by October 1st. You've said you've figured out the photo album and we'll have a evidentiary hearing regarding the life insurance policies. And I hope to meet with everybody ahead of time so that we can, you know, I mean, if you can get me the documentation, it seems like we could sit down and if all the documentation is there, there probably doesn't need to be much testimony, but we'll have to see. Good luck, everybody. Anything else, Mr. Swears?
No, Your Honor, just as always, I'll coordinate with Ms. Erdlin if we can exchange. I just got some additional documentation. We'll let the court know as soon as possible if we're able to work this out without needing the evidence hearing, but fully agree should be short if anything. So thank you, Your Honor.
I sure hope so. Ms. Erdley, anything?
Nothing further. Thank you, Your Honor.
All right, Mr. Swears, I guess you'll draft the order, especially as it relates to the amount owed and stuff.
Yes, Your
Okay.
Honor.
All right,
Thank you.
Good luck. Thank you. Have a good weekend, everyone.
Thank you, Your Honor.
Miss Bailey Hobbs, we got you after your hearing, I take it?
Yes, good morning, Your Honor. Thanks
Good
for
morning.
the flexibility.
No problem. I'm really a pretty easy guy to get along with, whether you think so or not.
I hadn't formed
Wait a
anything.
minute, my clerk just laughed. Then I got to have a moment of silence with her. 50DM Smith v. Smith. This is both parties are present via Zoom. Miss Bailey Hobbs is present on behalf of the mother, Miss Smith. This is father's motion for parenting time. There was an order a while ago that started some parenting time. I believe he was to have Saturday, like telephone contact or something. Stip an order from 5/14, telephone contact with the boys every Wednesday at 7:30. And he's now asking for, go back the way it was, man, it's forever ago the way it was. So obviously his motion is asking for some addition beyond the Wednesday time. Is that correct, Mr. Smith?
Yes, sir.
You have a place where you live and all that kind of stuff?
Yes, sir.
Living, working, that kind of stuff? Have you been having the Wednesday contact with the kids?
It started off on Wednesday, then Eliza and I determined based on my work schedule that the 15-minute window that I was allowed to have on Wednesdays with my work schedule wasn't giving me enough time to hardly break the surface with conversation. So we transitioned it to Sunday afternoons.
So she's worked with you, sounds like.
She is.
All right. Miss Bailey Hobbs, I mean, I'll tell you that I'm going to eventually start to increase some type of parenting time, not necessarily a weekend or something like that, but I'd be interested to hear what you have to say. Miss Smith is working with him. And so let's hear what you have to say.
Thank you, Your Honor. First off, I'd like to address the fact that Mr. Smith's motion is not filed pursuant to the court rules. MCR 2.119A1 states that the motion must state with particularity the grounds and authority on which it's based. Mr. Smith's motion is 2 or 3 sentences long and is merely a request for relief. He has not alleged good cause or change of circumstance different from the circumstances that were present in May when the parties entered a consent order. That consent order was not entered as a temporary order. The court's well aware that there are standards that need to be met when modifying parenting time. So I'd first like to make a motion to dismiss based on failure to identify any good cause or change in circumstance. But then I would like to address the court's question after that.
I'd like you to address the court's question because he's in, look, I've dealt with Mr. Smith on a couple of occasions. I think he was down in Texas originally, weren't you, sir?
Yes, sir.
And he didn't know where his kids even were, and he was trying to find out, and then he made another motion, and I was saying, I don't know what good it does to give you time when you don't even know where they are. Somehow they've reconnected and made some kind of connection so that he at least, I mean, his kids are what, 15 and 13? Is that, do I have that correct?
Yep. Yes, Your Honor. The 13-year-old will be 14 in November.
Yep, November 18. So,
Yes, sir.
You know, the reality is that at some point he's going to be able to reconnect with his kids on something more than just a phone contact. That's why I was asking if he's had since May through now and they've worked with it and the kids have had contact, and I'm sure it's not perfect and all that kind of stuff, but they have had contact. I'm looking to see what your client thinks about having some, whether it's supervised or whatever, meeting with the kids. I'm not going to reinstate what he asks for every other Tuesday or Saturday and Sunday. It's not appropriate at this time. Maybe somewhere in the future it will be. So please address my question then.
Thank you, Your Honor. My client proposes that I don't know if he's plaintiff or defendant, that the plaintiff or Smith start participating in reunification therapy with the children. That could be done in person. It would give the children a bridge to get to know Mr. Smith and start to form a bond with him. As you stated, they have not seen Mr. Smith in years. Miss Smith is concerned about the oldest child, Elijah. He has severe Crohn's disease. And so a significant stress would potentially flare that up. And so one of the reasons why she thinks it's appropriate to do the reunification therapy would be to help ease that transition. There has been phone calls since May. Some of those phone calls have lasted 2 minutes. Some of them have lasted up to an hour. There was a period of time in July where the phone calls were lasting a little bit less than 10 minutes. Sometimes they were 14 minutes.
Like I say, I understand. I'm not going to force these kids to go stay at his house from Friday to or Saturday to Sunday overnight and stuff like this. Reunification. I mean, who does she want? What about something as simple as the kids would go meet their dad and the name is nothing, okay? Whether it's Denny's or whether it's I just had somebody go to the food court in the mall, Woodland Mall, or whatever the other mall is here, or meet at McDonald's. Maybe one of the kids' the kids have a favorite place to go to eat or something like that. Just to go there. Mom can, drop there, but stay kind of around. I'm just trying to get him to meet. I'm afraid that I don't think either of these parties, I don't know that Mr. Smith has a lot of extra money to be going to a therapist and stuff like that. I'm not trying to make the kids worried about it. They just go and they have like I say, I'm just using this name. So they go to Denny's and they meet at 6 o'clock on a Saturday. He buys them dinner, talks to them a little bit, and leaves within an hour or so. And Mom, you're not going to sit at the table with them, but you can be around there and stuff, or sit out in the car or whatever. The kids, they're also not little kids, so I'm not worried. He's not going to, he's not going to eat them for dinner. He's just going to have to try and establish. Sir, you got to work on reestablishing contact with the kids, okay? You need to work on face-to-face. You need to start working on this and slowly work back into it. That would be what I would like to see. And I'd like to hear from Ms. Hobbs, Bailey Hobbs, if you don't mind. I'd like to hear from Ms. Smith for a minute on what would be a favorite place that they'd want to go, just for a dinner or something like that. You know what I'm talking about. Would they rather go to the zoo? Whatever.
That's fine, Your Honor. I instructed Ms. Smith before the hearing when we spoke yesterday that you may have some questions for her. Yeah, Ms. Smith, tell me something that would be kind of nice for the kids and they'd see it as a good thing, and you're just going to talk to your dad for, I'll be back or get you in a short period of time. What would I'm letting you make the spot.
They're boys, they love food. So I would say
Yeah.
it's probably going to be your biggest way in. So I would say probably going to somewhere. I know they really love like Olive Garden and some of those ones.
Would they feel comfortable there?
I'm not sure they will feel comfortable anywhere for a while.
Well, they won't feel comfortable even if it's a reunification therapist. They aren't going to feel comfortable going to a therapist's office. All right. I can't imagine they're going to go, oh yeah, this is great. I'm going to go to a therapist's office who I don't really know and meet my dad who I haven't seen in forever. I think they'd probably feel better. Yeah, we're going to go to the Olive Garden, or sir, could you take him to the Olive Garden Saturday at, I don't know, 5 o'clock or something?
The location doesn't matter. I'll be able to take them anywhere. But I just want to throw this out there. I live on a campground. I have a grill. It allows us a safe environment that we don't have to worry about the public eye. And
Yeah, but
she could stay on grounds. It'll give.
I want you to know the first time or two, I do want them out in the public feeling that they're, you know, they haven't, when was the last time you physically saw them?
It's been close to 7 years.
All right. So, and at that point, I mean, geez, oh, Pete, your kids were 8 and 6 or whatever. All right. And I'm not saying you're a bad guy at all. Okay. I'm just trying to make it simple for the kids. And if you would meet at the Olive Garden at, I don't know, 5 o'clock on Saturday or Sunday or something like that, you have that time off work?
Yes.
And mom is just saying they'd probably like to go there. I'd like to go there if you want to buy my meal too. I'm not going to supervise, but I'd appreciate it. You know, how about doing something like that? And you could do it. I'd tell you should be allowed to do it each week. It doesn't always have to be. Listen, Miss Smith, are you able to contact Mr. Smith at all or anything?
I am, but he does live almost 2 hours away, so that
Well,
I don't have time to drive that all the time.
Well, where do you live? Don't give me your address, but where do you live?
I live in Portage.
Okay. So that's by Kalamazoo.
Yes. Mhm.
And sir, you live up in Grand Rapids?
No, I'm over in Grass Lake, Jackson area.
Oh. All right. Find a spot somewhere where she doesn't have to take the kids for a long drive. This is all a preliminary thing. This is all to just get things started. All right. And if you get to the point where, you know, the kids seem pretty comfortable, I kind of think mothers, if the kids are comfortable, I think mother will be kind of comfortable also, because you know where I'm going with this, Miss Smith. You can talk to your counsel, okay? And maybe she'll get to a point where Saturdays, yeah, you can pick them up at noon and grill out with them, or that'll be winter, go sledding. I don't care what you can do for a while. And get so they're comfortable. When they're comfortable with you, we'll start talking about having, you know, Saturday through Sunday or something like that. All right, but not right now. If you want to set a time and place, ma'am, I don't care if you want to start it this Saturday or Sunday or next Saturday or Sunday, that I'm going to leave that to you. And you set a time and a place and he'll be there. Ms. Smith?
Give me 1 second.
You can tell me.
I mean, I was honestly hoping for supervised visits, but
it is kind of supervised, okay? Because they're going to be in a public place, all right? And I really don't think kids at this age are not that thrilled to, I mean, who do you want to supervise it? You'll be the
neutral party, but Olive Garden, I guess. There's one in Portage, and Sundays are better.
All right. Sunday at 5, 4?
Sure.
Well,
5 is good.
5 o'clock. Can you do it this week, or if you want, I'll let it start next week.
This week I was supposed to take them to Grand Rapids for their grandmother's birthday on Sunday, so I can try and get back in time for that, but that might be.
I'll tell you can start it next week, Sunday.
Okay.
Right? He'll still have that time that he can talk to him on the phone and stuff like that, okay? But we'll start it. He'll be at the Portage Olive Garden at 5 o'clock next Sunday. All right? And make it just as easy as can be. The kids, you just tell them it's no big deal. You're going to go have dinner. Go have dinner. What a great time. and, we'll see, after that, we'll set Sunday at 5 o'clock. I won't set a specific place. Talk to Miss Hobbs, Mr. Smith, you talk to Miss Hobbs and see if we can have a place. Ma'am, if it goes awful, Miss Hobbs will make a motion to me, okay? If it's terrible. Mr. Smith, if it goes good, you can resend in your motion somewhere down the road. I'm not gonna have 2 good visits and then suddenly give you every other weekend, right?
Right.
I'm gonna have you break into it. All
I
right?
appreciate it.
Talk to the kids, find out how they're doing in school, what's their favorite subjects and all that kind of stuff, and enjoy the time. So, and it'll be for an hour and a half. It probably takes an hour and a half at Olive Garden to eat. The following Sunday, which is like the 14th or 15th or something like that. First time. And I'll give you an hour and a half every Sunday to take them to a public place. I hope you guys can agree on it. I'm not asking you anything other than you're gonna have to do most of the transportation at this point, sir.
That's fine.
So, ma'am, you don't have to drive an hour or two on Sunday. Just get the kids there and let's try to work together. The reason I'm doing this is because, ma'am, you were able to mediate this. I give you credit for it. You were able to also give some credit for setting up a different time than is in the court order, which you wouldn't have had to. And you're doing that, and so that's why I'm giving you so much room on this. All right? Let's just see if it'd be great. I'm sure you know it's best if the kids have a relationship with both parents, and we'll see what happens. All right, Miss Bailey Hobbs, want to draft this every Sunday, basically starting next week for an hour and a half at 5 o'clock. First one is at the Portage. That can be the default place, but let's work on going to a couple different places. So you guys could email or text and say, how about this week we go, ma'am? All right. You know what I'm saying?
Yes.
All right. Anything else, Miss Bailey Hobbs? I appreciate your assistance here.
Nothing from me.
All right. You'll draft the order and send it through on a 7-day?
Yes, Your Honor.
Means, sir, if she's going to draft the order and send it, she'll send a copy to you. If it's not what I ordered, then you can object to it, but you got to do it within 7 days of receipt of it. I'm sure she's going to send me what I ordered because it's not very complicated. All right.
Thank you.
Good luck. Thank you, everyone.
Thank you.
We're adjourned. Thank you.
Good morning, Your Honor.
Morning. Can't see. You got to sit down there or something, because all I'm looking at is from your shoulders down.
Yes, Your Honor.
There we go. I think. All right. We're here on case, it's Mitchell v. Hall. Both parties are present via Zoom. This is a motion by the father for custody. He says, can't handle the child, wants her mother to do guardianship. I don't know, referred to the friend of the court, didn't accept diapers and stuff for a while. I've read mother's response to all this too. Earlier this year, sir, you just indicated you were homeless. I don't even know if you have a place where you're living. What is, in order to change custody, you have to tell me there's proper cause or change of circumstance. And
yes.
What is the change of circumstance that we're dealing with since the last order or proper cause?
Yes, Your Honor. Chelsea Mitchell, the plaintiff in this case, is constantly leaving Harmony with her grandmother, Harmony Lee Mitchell, with her grandmother, Jennifer. She's begged people online for food and items. When I've offered on multiple occasions Harmony food and items for myself as her father, she showed a lack of being able to fully provide for Harmony.
And why is Harmony below weight or something like that? I mean, is she?
Yes, she's behind, as well as Chelsea Mitchell's 2 other children. I'm worried for Harmony's safety.
Yeah, something from the doctor's office, or she's in the 3rd percentile or something like that?
Yes, Your Honor. I attended Harmony's birthday party, and she didn't change Harmony Mitchell. I did, and then I went to Harmony's doctor's visit at her 9-month visit, and there was a diaper rash reported for 2 weeks that was unattended. Chelsea Mitchell,
Ms. Mitchell, I've heard her response
to the rash and said that she went to the emergency room for it.
Kids get these things, and apparently she took her in for it appropriately. Ms. Mitchell, what's your response?
Okay, so Harmony did have a rash. I was using Vaseline and Desitin for the rash. It was not clearing up. That's why I took her to the ER. They told me to let it air out and breathe more than what I was already doing, but keep doing the Desitin and diaper cream to get it to go away. And then if it didn't go away, to take her into a primary care doctor. Mr. Hall has wanted to go to her. This was back in February. So Mr. Hall wanted to go to doctor's appointments. I was like, okay, well, this is where it is. He showed up. And so that's why Harmony went to her primary, because it still wasn't working. So she prescribed Harmony a medicine form of diaper cream, because she said girls, females in general, are more prone to getting rashes than boys are anyways. And that sometimes Desitin and stuff does not work properly in that medicine diaper cream.
Let me just stop you for a minute, all right? Sounds like you've done everything that the doctor has told you to do to try and take care of it, so that's a non-issue.
Yeah, Chelsea has had her children around her other baby's father. He is an alleged molester. It's the same person that has been around Harmony Lee Mitchell.
What do you mean, an alleged abuser? Has he been convicted?
Alleged molester and abuser. No, I'm not sure if there's conviction. There's just allegations.
Well, geez, oh, Pete, anybody can make an allegation against you.
Under investigation, yeah. Not me.
Well, but I'm saying,
big father.
I can't take a kid away because you're saying he's an alleged. He probably denies it. And all that
I apologize, Your Honor. I apologize, Your Honor.
Yeah, look at that, Mr. Hall. I'm not trying to run you down at all. I believe you have an honest desire for the best for your child. All right.
Thank you.
I do, but I don't think that at this point I have a proper cause or change of circumstance to change custody. What I'm looking for right now is, quite frankly, the friend of the court is supposed to be doing a report on parenting time. I'll get a lot of information on that. So, what?
There's more if I'm able to wrap this case up, Your Honor.
Yeah. What?
Okay. Chelsea Mitchell cannot provide stable housing for Harmony Lee Mitchell. She was living with her mom. Then she was living with her best friend. Then she went to her dad's. And then now she's back to her mom's. She has Harmony Lee Mitchell around alcoholics, which is her father. I don't trust Chelsea Mitchell. I don't trust Harmony Lee Mitchell with Chelsea's boyfriend. He yells at Chelsea Mitchell's kids. And he did that at the Harmony's birthday party.
Chelsea, what at Harmony's? When was Harmony's birthday party?
July 28th, right after the court hearing. The previous one, which I denied weekly overnights with Harmony, because I had argued with Chelsea following up to being asked if I want weekly overnights with Harmony. I also want, if I cannot get custody in this case, I want immediate court order, because the Mitchell family only listens to court orders. I want immediate court order visits and overnights, Your Honor.
Do you exercise any visits with her?
Yes. They don't. The plaintiff party does not exercise visits.
When do you see Harmony?
When I have to press the plaintiff party, and it's not. I just have to constantly. I'm blocked by Chelsea Mitchell, so I constantly have to contact the plaintiff party.
All right,
like the mom, Chelsea's mom, and the aunt. The aunt has partial parental rights.
Let me state for the record that on 8/5 I signed, 8/6 the judge signed a referral to the friend of the court for parenting time. That's a month ago. Have you been contacted by the friend of the court? They will do a complete evaluation. I hope you will cooperate with them. I waived the fees and everything so that the two of you will cooperate with the friend of the court. You'll talk to them. They will make a thorough investigation and tell me what they think is appropriate for this. Ma'am, have you got anything from the friend of the court yet?
No, I have already talked to a friend of the court, but Your Honor, I would like to let you know that Jaheim Hall did not even serve me papers for today, yesterday after 4 o'clock. He didn't even serve me where it says that it's on 8/20 certified mail. I didn't even get any of these papers for this custody hearing until yesterday.
How on earth would you have answered his motion that I got your answer to it if you didn't know about it?
Because I had to call friend of the court. Well, and that's how I found out.
And so you got his motion because you answered it. All right? So you didn't find out last night. You
No,
answered
I'm
his
saying
motion.
he didn't serve me the papers until last night. I'm not saying I didn't. No, he did serve me the papers.
But you answered what he talked about, so you must have gotten something to know.
Okay, Your Honor, this is emotionally affecting me, and I'm blanking. So, I'm just gonna say, if I cannot get custody, I want immediate court order visits to overnights. There was an amended court order I showed the plaintiff party. They have not been following it. I didn't get 2 hours of parenting time the last time. I got an hour and a half. And
If they violate the court order, file it with the friend of the court.
They missed the last one, and the one previous to that was an hour and a half, not 2 hours. They are not listening to the amended court order of parenting time.
Listen to me. If they violate the court order, submit it to the friend of the court. There is a process.
It has been submitted twice to the friend of the court.
That's fine. They will go through it, just like the friend of the court will go through the evaluation regarding parenting time. I'm going to wait and see what they have to say. You should make sure the friend of the court knows your address and stuff. They're sending you stuff for it. And
Your Honor, I would like to,
until that time.
Your Honor, may I eject and say I would like to request a court order app for all communication?
Do you guys want to do app close? I think that's
app close, please. Yes, Your Honor.
Your Honor, Jaheim Hall is lying because I have given him plenty of opportunities to give him. It's all in text message. I have
not changed any prior orders at this time. You're going to go through the friend of the court. If you're violating an order that is out there, he will send some to the friend of the court. If he does, they'll investigate it. If you're not following the order, I will hold you in contempt. That's a period of time. You will both communicate through the app close app from now on, so that I can get a clear understanding. That's no other way that you will communicate. So you go online, find app closed. It's like an Our Family wizard, but it's free. So you will start communicating in that way because you guys can't communicate any other way.
Correct, Your Honor.
All right.
I'm currently in Harmony's room. I also have a crib for Harmony Lee Mitchell.
So, all right, I do not find Vidvarka here. I'm sending it, again, I'm still sending it to the friend of the court. Parties will use app close for all communication from now on. Thank you all very much. We'll look forward to seeing you after the friend of the court does their evaluation. Thank you.
Thank you, Your Honor.
Okay. Thank you, Your Honor.
There will be another hearing.
Yes.
Thank you.
We have present the plaintiff. How do we know Mr. Barnes got word of this? Is he in the Kent County Jail?
That was the last address I had for him that the court gave me. They gave me the file. I went and did the last address that they had. I don't be talking to him. He bounces house to house. He's homeless. Like, I just know he has a job and he bounces house to house. I don't know.
Is he in the Kent? I mean, you have listed here where you tried to serve him at the Kent County Jail, right?
That's what I was given, yes.
Are you checking? Well, you're looking to find out if that's even proper. This is a DS case was initiated long time ago. Ma'am, in the DS case, it says the mother has initial custody of the child without prejudice to the determination of either party's custodial rights. You have custody. Nobody's asked for any kind of change at this point. You want to have a hearing to determine if the custody that they say you have?
Like some proof or something. Like, it's just a roller coaster with him. Like, he'll pop in and out my son's life. That's emotional stress on my son. My son has ADHD. It's stuff going on. I'm tired of either the no caller IDs out the blue, or I'm all types of bitches and stuff. He's not doing nothing. He's mad about child support. It's just a whole lot. You just keep having kids. Like, I'm tired of that. Like, when I was, like, for example, the reason why I had set this up is because last year, when around this time, I had to go through the courts for my son to go on a cruise with me because the cruise line said because he's on the birth certificate, I have to get a paper sign. Tried to get the paper sign from him.
He didn't want to do it. I'm not going to terminate his rights.
I'm not terminating. What I'm saying is, it's no help. It's no financial help. It's no help there. He's not reaching out to me because he's not getting his son. He can't even tell you nothing about his son. The only time my son seen him this year was one time this year, and that was for 2 weekends in a row. We had set up. We talked to him when I got in contact with him. We set up that he'd get cash every other weekend or every weekend, and that's what we came about. He got cash one weekend, the next weekend for his daughter's birthday.
What do you think I can do with this? Issue an order that says he's got to be a good father? I mean, there's an order for child support.
for child support, but that's not doing nothing. And then on top of every time he comes around, I have to call the police on him. We have multiple domestics of him putting his hands on me or acting out around my son. Like there's paperwork and paper trials there. There's everything leading up to this. It's been 5 years. I'm not getting no help with
And
nothing.
parenting
Child
time,
support,
the only parenting time order is as agreed. So you don't agree to parenting time.
there's nothing that I'm not getting with none of this though, sir. Well, that's what I'm saying. It's not about the child support. It's not about the money. It's not about none of that. It's the fact that you're popping in and out my son's life. 1 minute you're here, 1 minute you're not there. You're not helping with my son with anything. My son
What
has a
is
high
it
form
that you
ADHD.
think
My
I
son
can
has
do?
a
You have
I asked for
custody.
this court for my full custody of my son. Like, what's going
You
on?
have
Like,
custody.
so I'm saying, like, is there a way if this man tries to come take my son or do something with my son, he can get in trouble? That's where I'm getting at. I already know I have custody of my son. My son's living with me, with what? But I'm saying, like, the real deal. When I go take my son to go fill out for his passport next week, I shouldn't have to argue with the people and them have to tell me his dad has to be there. I need, like, my full custody, like, everything. Like, I'm not getting nothing with this man. I'm not getting no help, no nothing. He shouldn't even have to have no rights to a kid, and he shouldn't.
Well, again, I'm saying I'm not going to
Out the
terminate his
country if I
rights.
want to.
All I've got is you
because I
have
need
the
him around
only
to sign
order
stuff.
of custody right now is the only order that you have. And you have custody unless you want to have a hearing that gives you custody. You have custody. He has ordered to pay child support. I'm not able to make him a good father. I'm not able to change some of those things. If you can't get something through a passport, I'm not going to remove his name from the birth certificate because he is the father and I can't do that. So I don't know what you're asking for. And you can unmute because I unmuted you because you just keep going on with the same stuff and I can't do anything. I don't know what you want. You have custody. You don't have to agree to parenting time. The only parenting time he gets is what you agree to. And if you don't agree to him, he's the one who's going to have to come in and ask for custody for some type of parenting time. That's just the way it is. Is he going to be around you or something like that? I suppose. But I don't know what else you're asking for. You're asking for a custody hearing on custody that you have right now. If you want to answer me, you can unmute. Otherwise, I don't know what I can do. If you got to go for a passport and they say you've got to come through me, then you have to. All right. I'm sure I'd agree that you'd be able to get a passport for your son. I can't think of any reason why you shouldn't. Unless he showed up and had some reason for it, but I always let kids get passports. I don't know what you want. Do you want to unmute or are you still? Hello? Got to push your button to unmute if you want to answer anything. Well, I guess you have nothing further to say because I've told you have to unmute. You haven't. I guess what you're asking for, you already have. So I don't know what you're trying to obtain other than you get custody, and that's the only order that's out there. So as far as the other stuff, there's nothing to it. So I guess I'll deny the motion at this point because you already have custody. Good luck. Thank you. DC, it's matter Jewel versus Murphy. Both parties are present via Zoom. This is a motion filed by the defendant, Miss Murphy, to enforce parenting time, I guess. There was an order back in 2023, around July 2023, that allowed change of domicile, that Mr. Jewel was allowed to change the domicile up north. And it stated in there that there would be reasonable parenting time as prescribed in the prior order. The prior order said basically that she was to get every other weekend, Saturday noon to Sunday at 4. The exchanges at Reed City McDonald's. FaceTime also Wednesday at 6:30, and also talked about some type of holiday parenting time. That's what the prior order talks about. I don't know. You say you haven't seen the child for how long, ma'am? Miss Murphy, can you hear me? Great. You send her something or whatever. She's frozen. I don't know what. Good.
Your Honor, may I make a statement?
No, because she's not on yet.
Oh, okay.
Just mute yourself for a minute because she's not logging back in. I'm going to take another motion in between here, okay? But I don't want you to leave so that if she comes back.
Yes, Your Honor.
All right.
Yes, Your Honor.
But just mute yourself for right now and I'm going to do another motion in between.
Very well. Yeah, yes, sir.
Mr. Reyes, can you hear me?
Yes, Your Honor.
Did you send this motion to the plaintiff?
Yes, I did, Your Honor.
All right. When did you send it?
Like a week after I got it, Your Honor.
All right.
And, Your Honor, I also sent pictures of it.
Matter of Garcia versus Reyes. The motion says I wanted to file a motion for my overpayment. Mr. Reyes, this motion does not comport with anything close to what you have to ask for in motion practice in front of this. I have no idea what you're talking about, how much, where, when, why, anything. How do I even know there's an overpayment?
Well, that's what I asked. I had the paperwork that I told them that they needed it at the clerk's office, and they said no. And it said that's what it gave me 60 days to do it. And it said I overpaid.
How am I supposed to make a determination on if there is any overpayment? I don't have any information. I don't even know if it's true that you overpaid.
Yes, Your Honor. Your Honor, I got the paperwork at home.
It doesn't do me any good. And I don't know what it was in for filing and stuff like that. I mean, I can't grant a motion like this because I don't even know how much. Is it $8? Is it $800? Is it whatever? I don't know if the friend of the court said you overpaid or what. The motion, I have nothing, and it does not comply with the requirements for filing a motion with the court. There's no factual basis. There's a request for a motion for my overpayment, but it doesn't give me anything that I can even deal with here today. So
yes, sir.
I don't know what else to tell you. I have nothing to deal with. So I have to deny it because I don't have anything. If you want to try and put something together that makes some sense to me, that's fine. But there's absolutely nothing. I have no information.
Yes, Your Honor. So I need to go back down there then and send more paperwork.
I don't know what you need to do. I'm telling you, with what you filed, it's completely insufficient. I don't know anything about an overpayment other than you asking to be reimbursed for it. And if you are going to come back and you're going to do another motion for it, you've got to make sure that you serve the other party, at least if it's by mail, at least 9 days in advance. If it's personal service, which she's in Texas, so I'm sure it won't be personal, you need to make sure you send it to her. All right?
Okay. Yes, sir, Your Honor.
All right. Thank you.
All right. Thank you.
Thank you. All right. Ms. Murphy, can you hear me?
Yes.
All right. I don't know what you heard the last time. I just went through everything with the history of the case, meaning, did you hear any of it last time?
No, Your Honor.
Well, we're back on the record in Jewel and Murphy. Both parties are present via Zoom. This is mother's motion to enforce parenting time. Says she's been denied parenting time since last June. As of last July, after we entered an order in July that allowed reasonable parenting time as prescribed in the prior order. The prior order gave every other weekend, Saturday at noon to Sunday at 4. Changed at Reed City at McDonald's. Also gave FaceTime on Wednesday and talked about holidays. First of all, I cannot imagine why somebody would come after over a year of not seeing the kids and demand makeup parenting time. What have you been doing in all that time that you never saw the kids?
Speaking with Chris, and it wasn't after the order from July is from 2022, not 2023.
All right.
Or no, it's from May, the beginning of May. Chris was letting me see the girls like he was supposed to be for almost 8 or 9 months. And then after he had actually let the girls stay with me for 10 days, I never got to see them again. And Chris has done this before where he will stop letting me see the girls and usually it kind of smooths itself out. And it just hasn't at this point.
Let me just tell you that if you're not getting parenting time according to a court order, the first and only way you start with this is you file complaints with the friend of the court. They will do an investigation. They will make a determination how to proceed. They will contact everybody. And if it comes to the point where they think that there might be contempt, they'll file it and it'll be in front of me at a later time. That's the way you do this.
I've had 3 meetings with friend of the court and they haven't filed anything.
You have to file complaints with them, and I'm telling you, that's what you have to do. I'm not going to make a ruling on it today because I don't know anything about it. I don't know any reason why or what or anything. You file with the friend of the court. That's the way it's done. The method is set up there, and deal with it there.
I have filed with friend of the court. They told me to file with this court.
Well, if you filed complaints with the friend of the court, you should at least attach those to the motion and tell me something about it, because that's the way that the court operates, is you file with the friend of the court. Do they tell you that they don't believe that that there is an enforceable order, or what?
They told me to file with the circuit.
You're breaking up again. You got really crappy. I'm telling you, file your complaints.
They told me to file with circuit court.
Well,
they told me to file a motion
who
to
did that?
enforce.
Who did it?
Yeah, Chris hasn't let me see my girls. Like, this is a court order.
I'm telling you, I will enforce it through the friend of the court. File the complaints with the friend of the court.
Then I'll file the complaint with friend of the court.
All right, and if they tell you something different, get it in writing, and you'll have to get it in front of me. Good luck. Mr. Jewell, I don't really need anything from you. If you're not following court orders, you could get in trouble. Can't tell you.
Understood, Your Honor.
It's just the way it works. Good luck, everybody. Thank you. We're adjourned. Ma'am, you
Thank
have
you.
another one coming up also. It's going to be.
Thank you, Your Honor.
Thank you. You can check out Mr. Jewell. We have Mr.
Yes, Your Honor.
Murphy versus Arthur. This is Ms. Murphy's request to enforce a court order of parenting time. The only prior parenting time order that I have is from 5/5/23 that says weekends alternating Saturday and Sunday for 5 hours and 1 hour on Wednesday with exchanges at the Gaines Township Police Department. Ma'am, for the record, I just talked to her on a prior one. She says she hasn't seen the kids in over a year. And wants to enforce or wants to make up parenting time. As I've told you, Ms. Murphy, you must file with the friend of the court for any violations.
That's what I'm going to do.
And we'll deal with it from there. Mr. Arthur, you know what the parenting time order is. It's up to you. You know, I mean, if I find that you are violating a court order or without reason, you could be held in contempt. I don't know, but I'm not making any determination on that right now. If she's going to file. Just file her request with the friend of the court for parenting time violations. We'll deal with it. Maybe later with the friend of the court. Otherwise, you will be contacted and ask your version and all that kind of stuff. Good luck, everybody. Thank you.
Thanks.
He's not logging in. Ladies and gentlemen, this is the last motion for the day, and it's regarding child support. If we can get. Do you show, I mean, she has a confidential address, so he would have had to give this, I think, to the friend of the court for service. Do you show that they sent? There's nothing in the file about it, but he says, I mean, he filed this on 8/13. So I'm assuming, are they showing that they served? That's probably the friend of the court, I would think, because she has a confidential address. I mean, I don't think they'd serve it on him. Well, give him a couple minutes to connect.
Do you want to take us off everything?